Yes.
May I be permitted to mention regarding 253 of today's list, my lord?
Yes.
Very urgent motion, my lord. The selection process initiated for grant of license of a fair price shop. The private respondent has been selected. Who is not at all eligible for making application. As per notification. But it should not take 2 minutes time. Only one point, whether you are eligible or not. Any moment, allotment may be done.
253.
Yes.
When you file it?
The last week, when was not sitting, to appear on 6th,
So other matters are there. How can I add?
the allotment is granted, today, allotment has been granted. Allotment is matter.
I will start the list from today. 37. 37. Let's see how far I can go today.
Already
How can I? There are other matters. All important matters, motion matters. No, I can accommodate. Why I shall accommodate you? All the other matters are there. Let's start the list first. Let's see how far I can go today. Why is necessary upgradation? There are all matters, urgent matters, motion matters. You file late, then you are appearing in late. Other matters are filed 2 weeks ago. I have to dispose of these matters.
Only I came to know one of the 5 respondents has been selected.
Today, no. Today is not possible. Today, no upgradation. Yes. Let's see how far I can go today. Tomorrow, no. You come Wednesday.
My lord, may I be
List it.
My lord, may I be permitted to mention item number 204, my lord. My lord, I have filed this application, my lord, in the first week of July, my lord. My lord, I have participated in a selection process of fair ration price shop, my lord. My application has been rejected without assigning any reason, my lord.
Why you shall assign any reason?
No, my lord. I have submitted the application as per the criteria mentioned in the my lord notification.
They are not duty bound to submit you reasons like that.
My lord, nothing. Only one line. My
Yes,
lord,
rejected.
rejection. My lord, kindly
Yes,
appreciate.
portal is there.
My lord, 204. My lord, I have filed this application in the first week of July, my lord. My lord,
no interim order is required in this matter.
My lord, your lordship will not pass any interim order. Kindly hear
Let
me out.
Take up other matters. No upgradation. Yes.
I'm only permitted one matter, my lord. This is 301 of today's list. In this matter, the state has directed to file a report in the form of affidavit in the year 2022, but they have not still not filed. So only
whether they have filed it.
No, they have not still not filed it. So I am praying only let the matter come as to be mentioned, my lord.
For hearing.
For hearing, yes, for hearing. 301.
301.
301. Let the matter to be mentioned. I will inform the state. They will come and file the report, and also I will file the report.
Who is for the state?
Ritesh Ganguly.
Yes.
Only playing, I am already submitted notice. Only playing, let the matter to be mentioned. Only anything.
We mentioned Wednesday.
Okay.
Yes.
My lord, may I permit to mention item number 335. This, my lord, selection of a fair price shop, my lord, state has filed report. But your lordship fixed in the hearing. What a very short matter, my lord. Any day last week I have mentioned, your lordship told that mention on Monday. So, my lord, I come today, my lord.
Everything ready?
Yes, my lord.
335.
Yes,
Hearing matter?
Yes, my lord.
Okay, I can fix a date for hearing. That much.
Hot matter.
Item number 335 on mentioning this matter, we appear in the list for hearing at 26th of August 2025 at 2 p.m.
Yes, great.
My lord, may I have my lord's kindly
Yes.
mention item number 105 of today's list, my lord. I'm only praying for extension of time to deposit the cost. 105. 105. I'm only praying for extension of time, lordship, to deposit the cost before the learned tribunal. It will not take more than 2 minutes of my lord's time, my lord. Kindly, if my lord hears it out. Just 2 minutes it will take. Kindly, my lord.
This is MSCC matters.
Yes. My lord had disposed it off. They're granting us leave to deposit the cost before the learned tribunal, but the time limit that my lord had granted, that we missed.
Extend.
Yes, we missed that. Instead of 6 weeks, lordship, we filed this application also after with a little delay.
Who is for the
No,
claimant?
there is no other side. There is
Claimant?
There is no claimant because it was we came up in appeal against an ex parte order.
Yeah.
Because since we had already filed the written statement over there and it was accepted, that's why my lord had disposed it off with a direction upon us to file an application under section 5 and also deposit the cost within 6 weeks. That time lapsed.
Okay, it is appearing in another heading 2 mentioned.
We mentioned.
Today it can be taken up.
May I come back at 2 o'clock, my lord?
Yes, you come it.
2 o'clock. I'm grateful, my lord. Deeply obliged. Deeply. 105.
244. I mentioned this matter on last week. The Lord was pleased to direct me to mention today. If there's some urgency involved, the Lord was pleased to direct me to mention today.
If not taken up, I will take up a Wednesday.
244.
If not taken up today, tomorrow, let's see. I will taken up day after tomorrow, 244.
244. One is 270.
Two matter. Let's run the list.
If not taken up, well,
275. 275 for what?
for hearing. Hearing matter.
Hearing matter, I have to fix a date. Not taken up like that. 275, what is the matter?
That to granting of license.
I understand. So, who is for the state?
Omidullah Chetak.
Everything ready? Pleadings ready? Count 25 August. Please take down. On mentioning this matter appear in the list on 25th of August 2025 at 2 p.m. for hearing.
Your Lordship, Madam,
Yes.
Your Lordship, it's a one matter. It was a land matter, group one. Hearing matter, first item. The problem is, Madam, once it is hard, but state did not appear. Now we serve notice. And since then, Madam, 2 months have passed, Madam, it is not been taken up. Lordship, kindly fix, I am giving the number. First matter, item number 42, in the hearing, first matter, land.
Is it in the list?
Yes, Madam.
Then it appear in the list.
Running in the list, but it is could not be taken up due to other matters are there. So
I understand.
hearing matter could not be touched. That is the problem. We serve notice, but it is a very
So
short.
I have a fixed date for hearing,
Lordship,
particular date, not today. Let the list be appeared on Thursday. Thursday I will
be
fix.
appearing on Thursday. I will mention.
Yes,
Lordship,
Thursday you
allow me
mention
to
it.
mention because
Yes.
it was only when
Thursday I will take up your mention.
Sure.
on mentioning inclusion of the list.
Inclusion in the list. Group 8 matters.
My lord, may I be permitted to mention item number 127 of today's list? My lord, this is a restoration application. If your lordship kindly keeps it tomorrow, my lord, it will only take 5 minutes, your lordship. 127 of today's list, my lord.
So why are you mentioning this is under heading application?
Yes, my lord, if your lordship would kindly take up, there's a state might take any coercive action, my lord.
Let's run the list.
As
It
your
is
lordship.
appearing in the heading of application. What you want now?
As your lordship, please.
Yes.
Your Lordship, item number 227 of today's list, there is an extreme urgency, Your Lordship, in this matter.
227.
227, new motion matter. The urgency is that, Your Lordship, the petitioner filed the previous writ petition due to because the application of the petitioner on compassionate appointment has not been considered and the vacancy has been declared without considering the application of the petitioner. Thereafter, writ petition has been filed, and when Your Lordship was pleased to direct the state respondent to file a report, in the report, it has been seen that the rejection of the petitioner has been made. For this reason, the petitioner has challenged the order of rejection after withdrawing the previous writ petition. In the meantime, the the two vacancies which has been stated by your lordship on in the previous revision that has been going to take steps in those two vacancies. For this reason, this urgency has been arised.
227.
27.
Let's see today how far we go.
Your lordship kindly take
Today,
it up
no.
tomorrow or day after tomorrow as
No.
your lordship's convenience, because
Heavy matter there. 227. All new motion matters are there.
respondents are
No upgradation today.
step in regard to the
No
vacancy.
upgradation today. All the urgent matters.
If not taken up, then Wednesday your lordship kind.
You mentioned Wednesday. How far I can go?
May I see?
I permit to mention lordship item 224 and 230 lordship. This matter was mentioned by earlier weeks lordship by Mr. Patholotim. Due to urgency lordship, new vacancy has been declared lordship, and I am running the lordship.
Yes, all the urgent matters. Let me take up the matters. Otherwise,
Lordship declare the vacancy now 15 cards from my lordship Jasmine dealership. Now lordship, I am running lordship below 5,000. Now two similar matter lordship from the same area lordship vacancy has been declared. Now if they declare the vacancy lordship, and my mason dealer card will be lordship shifted from my dealer. Very small matter covered by your judgment.
let's start. Otherwise, how can I upgrade? It is all new motion matters you mentioning. I understand, but all new motion matters. If I upgrade one, everything would be.
We understand lordship.
Then-
Last week your lordship.
Yes.
To come this week. How far the
Okay, okay. Let me see. Let me see.
May
Okay.
I come back lordship on Wednesday lordship?
Wednesday,
Because they
Wednesday.
are already prepared the list of panel candidates. They will lordship declare the vacancy lordship by this week also. We expect by
You come Wednesday.
May I seek my lord's very kind indulgence to mention one motion of 2022 of the list and determination of my lord Justice Dinesh Kumar Sharma, my lord. My lord, the agency is,
Today, do I have the determination?
my lord, we have been told by the court officer, my lord. So no formal notice is there.
Let's check you. Nothing has reached.
So we have been told by the court officer that.
No, nothing has reached.
My lord.
So may I permit?
Mention that on the last occasion I have mentioned, your lordship directed me to come on Monday. Group 8 matters, item number 169.
One?
Urgent similar, because they are going to be filled up with a vacancy. If that vacancy be filled up, my writ petition will become infructuous. Your lordship kindly take it up, sir. This matter.
I will take up this matter if you permit me. New motion matters.
Your lordship.
I will take up the matters very shortly.
On the last occasion, your lordship directed me to come on Monday.
How can I do, sir? How can I do, madam?
Lordship kindly, because this petition will be infructuous. They are going to be filled up.
I will upgrade on Wednesday. Okay.
So may I permit to mention, lordship, last Friday, lordship directed one assigned matter. In today's this is 89. Lordship directed the matter will be appear in the top of the list to be mentioned. But the matter
89.
89. Lordship.
Yes, it is in the list.
Yes, lordship.
Special assigned matters.
Kindly, there is a grave urgency on last Friday. Lordship was directed to the.
Let me
matter.
see whether I can take up this matter today. Not necessary for upgradation. Okay.
There are grave urgency.
Lordship, may I mention one?
Not necessary. It is in the list. I will take up this matter.
Your lordship.
Correction of an entry for correction of an order.
Have you given the number?
It's listed, my lord, it's appear under to be mentioned 101 for correction one. But there are a lot of fixed matters to be taken up before that and also.
Not the fixed matters. I will take up this matter one after another. (101).
101.
Yes, for correction. Let's see, I can take up this matter. today.
Upon notice,
Your lordship.
I'm mentioning this matter before your lordship because Friday, last Friday, it was mentioned by the senior counsel. My lord has directed him to serve a notice and come back. I have served and come back. My lord, kindly fix a date for this matter.
Which matter?
Land matter, my lord.
Group A1 matter.
Group 1 matter.
Into group 1 matter. Is it in the list? Then why are you mentioning today?
My lord, they are the land losers from 1970.
Come on Thursday. I cannot take up this list today.
Your lordship, may I mention one matter? Item number 87. This is assigned before your lordship. Lordship, the other opposite party is trying to create third party interest in the property. Lordship, in the meantime, there has been no stay order has been passed because this matter is a new motion matter. Your lordship, if
This is specially assigned matter.
yes, your lordship. In the meantime, if third party interest is created, your lordship, this will become infructuous. Lordship kindly fixes any date, your lordship, this week subject to your lordship's convenience.
I have no convenience to fix the matter. I have to take up the matter according to the list.
Your Lordship, this matter will become infructuous if third party interest is created.
This is a civil revision.
Civil revision matter, Your Lordship.
Let me start the list first. Okay.
Your
Yes.
Lordship, may your Lordship kindly 2024 notification matters, my lord. I will only be praying, my lord, for directions upon the state to file report, my lord.
20, what is
22?
this?
These are 20.
For listing.
Yes, for my 2021, these are there in the list, item number 2 and 5, because my lord, it will take time. So if it could appear under mentioned matters, my lord, so that my lord, I will only be praying for it, my lord.
No, today no
My
upgradation.
lordship had mentioned on Friday, lordship said to come on
Today no
Monday.
upgradation. There is very heavy list. You know that. I am not allowing upgradation today.
Item number 249 and 250 of today's list. Last Thursday, I have mentioned these matters. This matter is covered by your lordship judgment, because lordship's order, because this is the matter regarding the curtailment of the customers by the oil company. These two matters will not take more than 5 minutes, because these two matters are covered by your lordship's order, and
Come on Wednesday, I will fix the matter.
Wednesday.
Yes.
Your Lordship, may I permit to mention Group 8 matter, Your Lordship? Item number 257 of today's list, Your Lordship.
No upgradation.
Millet, under the compelling circumstances, Lordship has fixed some of the matter of the curtailment of the beneficiaries, and Lordship is inclined to hear the matter today. But I am reciting to you, Lordship, Millet.
Today is 11th.
Yes.
Okay, today is the date for fixed for hearing of these matters.
Some of the matters, my lord, and some on 18th.
Millet, I have some difficulty to Millet respond to the text.
Okay.
So let them argue on that event, Millet. I have already started my argument. So the point of maintainability, I have argued, Millet. Can it be?
You want, let them finish, thereafter you will take up.
May I?
Just wait.
Yes, ma'am. In method, in most
আমার পরপর অনেকগুলো আছে দাদা
Lordship was
Yeah,
just
the matter
listed
cover
direct
করে দেবো
item
সব।
number 249 and
তুমি যদি argument
your
করো
lordship
fundamental
Wednesday.
No, you mentioned this matter Wednesday. Not take up the matter.
So, my lord, so far as my lord, those matters are concerned, my lord, some of the matters are listed today, my lord, and some 15, my lord. In my lord, most of the matters today, my lord, I will be filing, my lord, the exception to the report, my lord, and all within time, my lord, all within time, my lord. So, my lord, it will be served today, and Mr. Chaudhary is also in some difficulty today, my lord. So, it could be taken up, my lord, any day.
Okay, next week.
Lord, in
Next week,
item
we'll
number
have fun.
37, Lord, I am
Some
appearing on behalf of the state respondent. Lord, I am opposing this application. I have filed my report in the form of
Item number?
37.
That's the first.
Let me first matter. Call
It's the first.
the
That's the
matter.
first.
My lord, may I have your lordship's kind leave to mention, my lord, a very urgent matter, my lord. Urgency is, my lord, offer letter has been given, my lord.
Item number?
Item number 257, my lord.
No upgradation.
My
No
lord,
upgradation.
kindly appreciate, my lord. The offer letter has been given, no license has been issued, and in the meantime, vacancy has been declared, and the last date of filling
I
up
will
the
take up
vacancy.
this matter, no issue.
My lord, on 14th, my lord. So, my lord,
No
it's urgent,
upgradation
my lord.
today. Let me conclude the
My lord, let the matter be.
Wednesday I will you mention this matter, I will upgrade.
My lord, Wednesday, my lord, again next week. It will come to next week, my lord. Last day is, my lord, filling up of the vacancy, my lord, in the same location, my lord.
Today I am not allowing any upgradation.
My lord, this is.
Let me start the
My lord,
list.
kindly appreciate, my lord. Kindly appreciate, my lord. Urgency
You
is.
cannot understand. All the matter are urgent matters. I
My lord,
cannot upgrade.
My lord, against the same vacancy.
You see the list.
My lord, this
All the
appointment
motion
was.
matters.
My lord, this appointment was given pursuant to the court's order, my lord. Pursuant to the order of the
I will take up this matter, not
My
today.
lord, tomorrow, my lord.
No.
Well,
You
tomorrow.
you mention Wednesday, I will take up the matter.
My
I will
lord,
fix the matter. Okay.
my lord. Okay.
Call the list.
Milord, 37, I appear on behalf of the state respondents. I have, in pursuance to your lordship's directions, Milord, I have filed my report in the form of an affidavit. They have also filed, Milord, their exception. It is ready for hearing.
Exception, have you filed it?
It has already been
Sir.
filed.
What is the exception?
Oh, not in the.
তাই তো বলছি
My lord.
Have you received the copy?
Lordship, Milord.
I'm fixing all the matters on 19th.
19th.
No, 19th. Just a minute. Yes, 19th or 26th. Subject to your lordship kind convenience.
26th, I can fix it, no issue.
26th.
Very well.
This is sir Monday.
Exception to the
Witness.
report in the form of affidavit filed on behalf of the state respondents.
Lord, we have already filed, my lord, the report in the form of an affidavit. my lord.
Exception to the report
File করে দিয়েছো কোর্টে?
in the form of affidavit filed on behalf of the state respondent be taken on record. Let the matter appear in the list on 26th of August 2025 under the same heading.
Lordship.
Next.
Oh, 38. Sorry.
Azibar.
Exception?
38, my lord, they filed their report.
Filed.
Yes, my lord. The exception is ready, my lord. It will be affirmed to all, my lord, as per the lordship's order, my lord, and will be served today, my lord. Azibar.
We have filed a report, my lord.
They have filed. Yes,
Report is
yes.
there.
Yes, yes.
Let it appear on 26th, same day.
Same date, my lord. Same.
26th. Exception
Let
in
the
the
matter
meeting.
appear in the list
Exception in the
on
meantime.
26th under the heading of hearing. Full stop. The petitioner is at leave to use exception against the report filed by the state within a week. Next.
26th, 26th September, না August,
August, sir.
It is August.
Exception?
Yes.
Exception to the
And served also.
exception to the report in the form of affidavit filed on behalf of the exception to the report in the form of affidavit filed on behalf of the state respondent be taken on record. Let the matter appear in the list on 26th of August 2025. 26th of August 2025 under the same heading. Next.
My lord, may I file the exception, my lord?
Yes.
These are all within time, my lord.
Similar direction. 26th. Next.
Your Lordship, appear on behalf of the state, Your Lordship. Copy may be served.
Then may I file the exception?
A copy may be served.
Yes. Sir, make it.
Similar direction, 26th.
Kindly note my lord, that it has been served. My lord. The
Yes.
exception, my lord, filed and served.
ওই যে লিখেছেন না exception to the report file লিখেছেন দেখুন exception to the report file on behalf of the ওই যেটা লিখেছেন আগের অর্ডারটা আগেরটা এটা সিমিলার বললাম তারপর be taken on record ওইখানে লিখেছেন কপি সার্ভড প্রত্যেকটা তারপরে সিমিলার ডাইরেকশন নেক্সট
But 42, my lord, we are still awaiting report, my lord.
Your Lordship, further time may be granted, Your Lordship.
report
Your Lordship, report is not prepared, Your Lordship. Kindly grant us further time, Your Lordship.
within a week.
As you deeply oblige, Your Lordship.
Can this be a peremptory direction? Because otherwise, on 26th, because this
All matter cannot be appear on 26th.
Yes.
I want to hear all the matter on 26th.
Yes.
Okay.
Perhaps my lord, this would be the third or fourth extension. So, my lord, let this direction be peremptory, my lord.
On the state no, an accommodation is short for on behalf of the state authority to submit a state authority for extension of time to file a report. Let state be directed to submit report peremptorily within a week after supplying a copy upon the petitioner. On such report, the petitioner shall be at liberty to use exception within a week. List the matter on 26th.
If your lordship would
For
kindly
hearing.
add that the directions are peremptory.
Peremptory direction, I have already written. Peremptory bolichu.
Oh, I'm so sorry, madam. I'm so sorry. But even IPS the petitioner, my lord, may I file the exception, my lord?
Exception to the report in the form of affidavit filed on behalf of the state respondent be taken on record. Copy served. Mr. Ghosh, have you received the copy?
Lord, just now.
Copy served.
And within time.
Let the matter appear in the list on 26th of August 2025 under the same heading for hearing.
Grateful man. না বাবা আমার এত মেধা নেই আজকে পড়ে আজকে করে নিতে হবে grateful my lord.
Yes, thank you.
The exception should be on record, my lord.
Yes, it is on the record. Ladies and gentlemen, let the matter appear in the list on 26th of August 2025 under the same heading. Next.
I am appearing for the state, my lord.
And may I file the exception, my lord? That copy served, my lord.
Exception to the report in the form of affidavit filed on behalf of the state respondents be taken on record. Copy served. Let the matter appear in the list on 26th of August 2025 under the same heading. Next.
Your lordship, there was a direction to serve upon the AG office, your lordship. This is the read down matter, your lordship. So
Yes.
whether they have served
Yes,
or not.
sir, on the previous occasion I
Your
submitted.
lordship, I have to take instruction from the AG officer, your lordship.
Not served.
I have no instruction that about this matter, your lordship. Kindly not make it not today, your lordship. I
See, previously I have served on the previous day.
Yes, affidavit of service is there.
As per the lordship's order, I have already communicated.
kindly make it not today. I will confirm it, lordship.
Then my lord, let it be taken up tomorrow at 2 p.m. my lord.
Why tomorrow 2 p.m.?
That's you.
I have already fixed matter at 2 p.m. I cannot take up this matter at 2 p.m.
Tomorrow, not today then.
Only not today.
Lord, I will take instruction, your lordship.
Yes, you take instruction. Not today. Next.
Not today.
Lordship, I beg to appear for the petitioner virtually, Lordship.
I'm for the private respondent.
Lordship, the last occasion the report was filed on the behalf of the state and petitioner was directed to file exception to that report. But Lordship, from the report, it is revealed that the successful bidder party, the respondent number 8, also
Today you
had not-
supposed to file exception.
Lordship.
What is the exception?
Lordship, I am taking the point. From the report, it is revealed that the successful bidder, the respondent number 8, also not complied with the provision for getting the fair price shop. In that particular case, Lordship, I have to categorically stated the points in my writ petitions. On that premises, Lordship, I am praying for not withdraw the writ petition and on the same cause of action to file a fresh writ petition, Lordship.
You want to withdraw this writ petition?
Yes, and again file the same writ petition on the same cause of action, categorically taken the point that the private respondent has also not complied with.
Issue after filing the all documents and
But Lordship, The Lordship, the difficulty is that after getting the report, it is found from the report of the state that the successful bidder, the respondent number 8, has also not complied with the provision and he has been allotted. Where it is stated in the report.
My client has not been proved. Let him say.
No, whether
It is
you
taken
want
in
to
an
proceed with
exception.
this matter
For
or
oral
you want to
submissions is being
withdraw.
made. In his oral,
Lordship,
they are
If you want
withdraw with a liberty to
not in the separate exception. Oral submission won't do. Nothing will be on record. Let him file an exception saying that I have failed to fulfill the eligibility criteria. On verbal submission, that cannot be. সেটাই বলছি there is a report, he has got it now.
At least I want an instruction, written instruction.
Yes.
Let the matter be fixed on Wednesday, Lordship. I am coming with an application affirmed by the petitioner.
Day after tomorrow.
Application for what?
Application for কি?
Withdraw.
Application for withdrawal. I don't know. Let him come.
Yes, let him come.
On the same cause of action.
Same cause of action. Same cause of action.
Okay, very well. Please take it. Learned counsel appearing on behalf of the state virtually submits that the petitioner doesn't want to proceed with this matter further. Petitioner is directed to submit a written instruction. Learned counsel for the petitioner is directed to submit a written instruction on that point. Let the matter
Lordship.
appear in the list day after tomorrow.
Lordship, kindly record it that withdraw the writ petition on the
You file instruction, thereafter I will pass the next.
Finally, record he doesn't want to file an exception to the report already taken on
Already
record.
there.
Lordship, kindly record it that with a liberty to file afresh on the same cause of action.
I
Not
am
to
not
proceed.
disposing of this matter. You come with the instruction.
Recording that I am
pass
not
out.
proceeding. Recorded that I am not proceeding, Lordship, it will hamper the right of the petitioner.
No,
Kindly
I am not passing any order. I am taking your submission only.
You want to withdraw this
Yes.
with the liberty.
Next.
Grateful, Lordship.
Exception.
Is the report there?
Report is there. Where is the exception? Have you placed the exception?
I am mapping for this.
Perhaps if the exception has been misplaced, I'll write to him and get a copy of the.
Okay. Same issue.
Same issue.
Let the matter appear in the list on 26th of August 2025. Petitioner is leave to use the exception within a week. Next.
49. I appear for the status for this. Report is already.
Yes, report in the record.
Report has already been filed.
Similar direction, 26th of August.
Now exception is now being.
Exception to the report in the form of affidavit filed on behalf of the state respondent be taken on record. Copy served.
In
26th. Next.
26th.
Who is appearing?
50, my lord, we've received the report, but only on Friday. So exception is getting affirmed today, and it will, my lord, served on them today.
Let the matter appear in the list on 26th of August 2025. Parties are at leave to exchange their affidavits in the meantime.
We've received it. This Friday we've received, and it's getting affirmed.
Next.
But we are still awaiting report from the state.
Similar order.
Well, report not filed.
Yes, report not filed. Liberty to exchange affidavits within meantime.
No. 52 affidavit file, Lordship.
Yes, my lord.
We are still awaiting the exception.
Yes, my lord. We shall file the exception, my lord. Lordship gives a week's time, my lord.
52.
It's getting
exception
affirmed.
not ready.
No.
Within a week. Petitioner seeks accommodation to file exception against the report filed by the state. let the exception be placed on record within a week. List the matter on 26th of August 2025 under the same heading. Next. Who is there for the petitioner? Not today. Next.
$54 IPA for the petitioner, my lord. We have received the report on Friday, my lord. It's getting affirmed today. The exception.
Very well. Let the matter appear in the list on 26th of August 2025. Parties are at liberty to exchange their affidavits, respective affidavits, within the meantime. In the meantime. Next.
The report is to be filed by the state.
My lord, Suman Sengupta is having some difficulty.
What is the status of the report? With the
My lord,
ready?
it's prepared, but it's not yet affirmed.
Similar direction. Let the matter appear in the list on 26th of August 2025 under the same heading. Parties are at liberty to exchange their respective affidavits in the meantime. Next.
Same, my lord. Still awaiting report.
Similar direction. Next.
And for the petitioner, my lord. My lord, the report has not yet been received, my lord. We have not.
Who is for the state?
State, my lord.
Miss Sonal Sinha.
5758.
5750. State is supposed to file an affidavit today. Ready?
No, your lordship, it is not ready, your lordship. Kindly a week time may be granted, your lordship, for that.
Both the matters are tagged.
Both the matters are tagged.
Or 57, your lordship.
Similar issue was there in the other matters like that.
My lord.
Let it appear on 26th.
Your lord.
An accommodation is sought for on behalf of the state authority. An accommodation is sought for on behalf of the state authority to submit a report. Let the matter appear in the list on 26th of August 2025. Full stop. Parties are directed to exchange their respective affidavits within the in the meantime. Next.
Copy যেখানে sign করবে copy sir চেষ্টা করে দিলাম my lord I appear for the state in this matter. We were supposed to file a report in the form of affidavit which is ready.
Okay.
Now my lord I am serving a copy also to my other side.
Receive.
My lord, may kindly record, my lord, that I have served here and now today.
Report in the form of affidavit filed on behalf of the respondent number 1 to 4 be taken on record. Copy served. Petitioner is at leave to file exception against the report within a week. List the matter on 26th of August 2025 under the same heading.
Grateful, my lord.
Thank you.
Next.
60 I pay for the state. Sorry, I pay for the petitioner. The state is to,
is there.
the state is to file the report, my lord.
Ready?
No, my lord, I am not sure in this matter. I am not holding.
State seeks accommodation for submission of a report. For submission of report. Let the matter appear in the list on 26th of February, 26th of August 2025 under the same heading. Parties are leave to exchange their respective affidavits in the meantime.
61.
Mr. Shirshannu Bandyopadhyay, Akash Dotto. No one is there. Let the matter appear in the list on 26th of August 2025. Parties are leave to exchange their respective affidavits in the meantime.
To IPA for the petitioner, my lord, we've received the report on Friday, my lord. It's the exception is getting ready today, my lord. It is getting affirmed today.
Okay. Let the matter appear in the list on 26th of August 2025 under the same heading. Parties are leave to exchange their respective affidavits in the meantime.
Your Lordship, I appear on behalf of the state, Your Lordship, report has already been submitted and served.
But may I file the exception? Lord?
Yes.
A copy may be.
Yes.
Why two exceptions?
There are two petitioners, my lord. They've affirmed their exceptions, my lord, my lord, separately.
Separate?
There are two petitioners, my lord.
Two petitions?
Yes, there are two petitioners, my lord, and they have affirmed their exceptions separately, my lord.
Two petitioners are there. Okay. Exceptions by both the exceptions by the respective exceptions of the petitioners against the report in the form of affidavit filed on behalf of the state respondents be taken on record. Let the matter appear in the list. Record copy served. Let the matter appear in the list on 26th of August 2025 under the same heading. Next.
64 my lord, I am for the petition.
Yes, Mr. Shah.
Matter what happened, my lord, on 22nd May 2024, the responding authority issued a vacancy notification for appointment of a fair price candidate. In response to the said notification, the petitioner made application for appointment. After complying all the formalities, it is found from the portal the petition has been approved. That is at page 29. Current status.
29.
Page 29, annexure P3.
Approved.
Approved, but thereafter withheld to issue offer letter and license. And no reason has been assigned why it has been withheld.
Yes.
Your Lordship, it is relating to the MAT 1543 of 2024. So, considering the, I'm reading the portion, Your Lordship, considering the situation on considering the aforesaid submission, state authority is at liberty to proceed with the selection process, but so far as to grant license is concerned, the same shall not be issued till the disposal of the batch of the appeals pending before the London Division Bench, being MAT 1543 of 2024. For that reason, Your Lordship, I think it is under.
Is there any interim order in this matter?
Kindly.
I know that order. 1543 of 2024.
For that reason, Your Lordship, the outcome.
You submit a short report, I will pass the
Yes.
order. You submit a short report.
Yes. Whether these
Having heard the learned counsel for the petitioner, state is directed to submit a short report within a week.
Yes, Your Lordship.
Within a week. Let the matter appear in the list on 20. 20th August. Under the same heading.
Yes.
Under the same heading. Affidavit of service filed on behalf of the petitioner be taken on record. Next.
Madam, I'm for the petitioner, madam. Affidavit of service. This is the matter where earlier my lord had interfered and passed directions, my lord, and thereafter the impugned notice under challenge is the notice at page. Starts at page.
Who is appearing for the state in this matter? Have you served?
It is, sir, page 20, my lord, 203, wherein a fine has been imposed. A sum of rupees 12 lakhs and odd has been imposed. And the reasons for imposing the fine, my lord, would come straight away, come to page 211.
Yes.
This is the fine which has been imposed.
Shortage of
So that's
MR
all-
commodities
MR
at the
commodities,
time
my
of
lord.
inspection.
Yes. Shortage of MR. I would prove before my lord. I would submit before my lord, which was earlier taken up for my lord, that the materials which were supplied to us were not of adequate quantity. If my lord takes up only once, my page. It would clearly reveal. If Annexure P16, my lord, 196 is the order passed by my lord. Initial order, first order. 196. P11 is the 187 if my lord comes to page P11.
So you appeared before the appellate authority. This is the order of the appellate authority.
Appellate authority order passed an order which was remanded back before the controlling authority. Controlling authority, we made the submissions. If my lord, the earlier writ petitions wherein I had filed the supplementary affidavit, my lord, would come to page 12 of my writ petition, my lord, paragraph 21.
Now you are challenging the order of the appellate authority.
Appellate authority. That is, this is the order which has been passed. Why this reasons has been come out? If my lord takes up, starts from page 54, the stock statement. 54 or straight away comes to my lord, page 30. Annexure P2. This is the stock statement which was supplied. There are card numbers are 1324. If my lord turns up the type portion which I have annexed.
Oh, what shall I do with these matters? All the lists. What you want now?
My lord, for quashing of this order, my lord, the impugned order that is at page Annexure P20. My lord, the order passed.
Order of the appellate authority.
Order of the appellate authority, my lord.
Let the report be come from the state.
Yes.
Otherwise, I cannot proceed. Full stop. Yes, please come. Challenging the order of appellate authority.
And if my lord,
whereby the appellate authority has affirmed. No, appellate authority in connection with an appeal submitted by the petitioner suspending his FPS dealership license. The instant writ petition has been preferred.
If my lord takes up page 175 once of the writ petition, my lord. This is the stock statement which has.
No, I understand. Let them come. Okay, full stop. It appears that the appellate authority has passed a detailed order, thereby imposing a huge fine upon the petitioner. Thereby imposed huge fine upon the petitioner. To ascertain the true nature and purpose of the instant writ petition and merits thereof, a detailed report required to be called for from the state respondent. Accordingly, the State respondent is directed to submit a detailed report in the form of affidavit against the writ petition within 3 weeks from date.
And my lord,
Exception, stroke reply, if any, by the petitioner against the report, be filed within 2 weeks thereafter. Let the matter appear in the list. No. Let the matter go out of the list. Parties are.
go out of this, it would be very difficult to.
You mentioned it after exchange of affidavit.
Very difficult to get it listed, my lord. It's very difficult. I'm bound down by before, my lord. Let it appear in some day.
5 weeks from date. Then it will be appear on September 22. September 22.
And my lord,
2025. Let it appear under the same heading.
Prayer age may be allowed, my lord.
What?
My lord, an order of injunction restraining the consent.
No. Without hearing it.
My lord, that would cause the fine has been imposed upon me. My lord, I have challenged that order.
You served?
But it has been served. It has been served. Affidavit of service.
You served this order without hearing. I cannot pass an injunction order.
If the vacancy is declared, I would be nowhere. I would be out, entirely out, man. If my lord, at least for a limited period, does not.
No. Without hearing other side, I cannot pass. Next.
The next one is that my matter only. 66 affidavit of service, wherein for this whole difficulty, my lord.
Same matter.
Same matter, my lord. There's a supplementary affidavit. My lord, may I serve the supplementary affidavit, and the affidavit of service may be kept with the record. This is the matter where I have this. It's a clear fraud which is being played upon entire state, my lord. It's a fraud. My lord, it turns to page 21, annexure page 211. Straight away.
No, in this matter, you have also challenged the same order?
No, not same order. I have prayed for an inquiry for appointment. My prayers in this writ petition starts at page. If my lord takes up the prayers. Prayers are at page, my lord. 25, my lord. I read in the nature of for appointing an appropriate investigating agency, my lord. Number? 66 C is appearing for the state.
This matter. You are asking for an appointment of investigating
page 211, my lord. Page
Why?
My lord.
211.
Yeah, page 211, my lord. Sees the ration card which has been issued by the state of West Bengal. Thereafter comes to page 212.
Let me see 211. You just
my lord, if
hear
my
the
lord
petitioner
turns
first.
to page 215. 215 page to annex P23.
Now, what is 211?
211 is the ration card which has been issued by the state of West Bengal. And the second part is issued by the central government. And the next part, 212, is issued by the central government. These are the cards. And these are P22 issued by the state government. How the state
211
is the central cards which has been issued by the central government.
State government.
Central government, my lord. These are the cards which were issued in the year
211.
11 is the card which has been issued in the year 2015.
2015. Where is the date?
If my lord comes to the second part, date is there, 2015.
2015.
Yes. And if my lord turns to page 213, Annex P22, these are the cards which are issued by the state government in the year 2023.
Yes.
These are the cards which has been issued. And if my lord turns to page 215, Annex P23.
Yes.
This is a card which has been issued under the category of RKS Y1 beneficiaries. And on the top of the card, it has been written. I have also annexed the delivery challan, which is lying on the left-hand side, my lord. In this card, when the card is being punched with card is being linked with the Aadhaar card, when the thumb impression is being given, the RKS1 card, as per rule, is entitled to 5 kg rice. But a person who is the card holder, beneficiary of the card, would get a 5 kg rice. But when we are, but while it is being punched with that machine, POS
EPOS machine.
POS machine, but getting only 3 kg. And the balance, what I am on in this matter is, I want an inquiry for this report of this. Why the balance 3 kg,
2 kg,
balance 2 kg is going on. This is totally a fraud which is being played throughout the state of West Bengal.
Please take down petitioner is a ration dealer.
Affidavit of service in both the matters are being kept to the record.
Okay,
Other
affidavit
matter
of
also.
service will be taken on the regular. Petitioner is a ration dealer. Who is catering ration articles to the beneficiaries. It is the contention of the petitioner while he intend to provide ration article from his FPS to RKSY capital hyphen the 2 beneficiaries hyphen the Roman 2 beneficiaries and punch the and by biometrics of the said person, the ration commodities which supposed to appear in the EPOS machine shows less quantity of ration, less quantity, while the RKSY hyphen the Roman 2 beneficiaries are entitled to the more ration articles. It is the submission of the petitioner that there are gross illegality.
Page 215, 216 also is the same. 216 is the same.
Gross illegalities and fraud upon the ration articles by the state authority. Instant writ petition has been preferred for appointing an appropriate investigating agency to investigate the illegal act of respondent authorities. Full stop. Having heard the learned counsel, for the petitioner, and also considering the nature of serious allegation against the state authority, it would be prudent to direct the state authority to submit a report against the writ petition. Let the report in the form of affidavit be placed on record within 2 weeks from date. Exception if anyway the petitioner within 2 weeks.
The same day, but the same matter, the other matter is also being returnable.
When it is fixed on 22nd.
22nd.
Let the matter appear in the list on 22nd of September 2025. Full stop.
At 2 p.m. Man, this matter.
Not 2 p.m.
This would be a returnable matter, my lord.
Let them file a report. Otherwise,
my lord, I have filed a supplementary affidavit today. I have served a copy. Supplementary affidavit and the
supplementary affidavit be taken on record. Supplementary affidavit.
And a copy has already been served to her.
Okay, supplementary affidavit be taken on record, copy served. Next.
APA for the petitioner, my lord. These are one of those notification matters, my lord. We've received the exception on, the report on Friday, my lord, and we'll be.
Let the matter appear in the list on 26th of August 2025 under the same heading. Parties are at leave to exchange their respective affidavits within the meantime.
Obliged.
Next.
I appear for the state lordship. On the last occasion, there was a direction upon us to give the affidavit in opposition. It might kindly be taken on record. They have already been served.
Exception.
We have also received a copy of the exception.
Affidavit in opposition filed on behalf of the state respondent be taken on record. Affidavit in reply on behalf of the petitioner be also taken on record. Yes. What is the matter? Today, are you ready?
Matter is ready for
You are
hearing.
ready? I can start it.
I am ready.
Yes, then start it.
Person. Now, see, this is matter regard to appointment of a MR distributor. Or MR dealers. I appointed. Inquiry was done. My cancellation was on the ground. My godown situated in a residential area. Only one ground. I submitted an RTI application. Kindly come to page 41.
Yes.
Page 41 of the writ petition. This is admitted fact. that my godown situated in a residential plot. There is no bar in the vacancy notice. If the godown situated in residential plot, license cannot be issued. In similar circumstances, state government already issued same plot in adjacent to my plot. Dealership is running, continues running. In my case, on the one ground, in my lease deed, there is a clause, I can continue. There is a clause, this plot only can be used for residential purpose. In similar circumstances, all plot were there. All plot were there. Now, subsequently, during selection process, I have been converted my godown from residential to commercial. That's also submitted before the authority. Authority, without considering that.
What is the document?
Let's see, can you come to my exception? Exception page 7. I know this is not required because in similar, like me, the state authority allows the continue FPS dealers. In my case, only count for rejection that my godown situated in a residential plot.
Now, what is page 8 of your exception?
Page 8, this is my lord, residential to commercial of my godown.
Whether it was allowed?
Yes, my lord, this is issued by the colonial majority. That was I submitted before the authority on 7th, 5th, 2025. My rejection subsequent.
7th of May, you have filed this.
Yes, madam. My rejection subsequent. Because I have been asked by the SCFS whether you converted your godown. I know yes. Well, then you can submit the document. I submitted before the SCFS. But DDPS without considering that document rejected.
Is there any person who appointed in this matter? No.
No, my lord. What happened, my lord? During pendency of the writ petition, they issued a new vacancy. That's also, my lord, kindly come to my rejection is 14 May. That vacancy issued on 13 May. How can it be, my lord? In my application was rejected on 14 May, but new vacancy was issued in 13 May.
Where is the new vacancy?
In opposition. Also, that vacancy not yet given effect because, my lord, that vacancy notice should be published in the newspaper.
Not published yet.
Not published yet. Page, my lord, 14.
Yes, I understand.
Lordship,
Yes.
as we had already submitted earlier, he had to submit some of the documents. One of them was the lease deed.
Yes.
And the lease deed, it clearly says our AO, Lordship, page 4, 6C. It is pertinent to mention that the petitioner had applied for fair price shop license, V-Day application number such and such. The petitioner had submitted in the application the Godown location at such and such. The petitioner had submitted a copy of the lease agreement with respect to the aforementioned land executed on 7/3/1995 between the petitioner's father and the governor of West Bengal. The lease agreement dated such and such as provided by the petitioner is annexed at page 24 of the said petition. Now, Lordship, come to D. After inquiry of the application of the petitioner, it was found that the terms of the lease agreement of land as provided by the petitioner, inter alia, states that the aforementioned land is to be used for residential purpose.
It's under government lease.
Yes, with the governor. And Lordship, when it says residential purpose only, undoubtedly running a shop, even if it is a fair price shop, that is a commercial activity. That is not residential activity. Now again, clause 4 of the lease agreement inter alia states, to erect, construct and complete buildings for being used for residential purposes. Clause 6 of the lease agreement further states, not to erect or build or permit to erect and build on the demised land any building other than that specified in clause 3, 4, 5, except in accordance with plans, elevations, sanctions, specifications previously approved by the municipal authority. Now he is showing one municipal authority certificate. Kindly check the date of that certificate, Lordship. On top, Lordship, what is the date? 24th June 2025, which is after filing of this writ petition. Clause 10 of the lease agreement further states, not without the previous consent in writing of the government to use or permit the use of the building or buildings that may during the said terms be erected on the demised land for any purpose other than residential purpose. Now, Lordship, when the terms of the lease deed are so clear, how can we permit? He cannot say that running a shop is for residential purpose. There will be people gathering outside. There will be people queuing up. And that might cause inconvenience to the other residents of the same building. How can he claim it as his matter of right when the lease itself, the lease on which his property is located,
where is the lease?
Page 24. Page 24 of his petition, Lordship. The clauses are mentioned in our AO. First comes to clause 4, which is in page 27, Your Lordship.
Yes.
Thereafter, clause 6. Clause 6, F4. For Lordship's convenience, if I may read clause 4.
Yes.
At the own cost of the lessee within 2 years from the date hereof or within such further time as the lesser that's a very
may at his option.
Clause 6, Lordship, clause 6.
Clause 6.
Not to erect or build or permit to erect and build on the demised land any building other than that specified in clause 3, 4, and 5 above, nor to make any additions to any building except in accordance with plans, elevations, sanctions, specifications previously approved. Why I say previously, Lordship? Because his municipal certificate is much later. Previously approved by the municipal authority or such other local bodies or any officer authorized by the government in that behalf, or in accordance with the provision of any law or statutory rules and regulations or bylaws applicable thereto. Next, clause 10. Thereafter, page 29, Your Lordship, clause 10. Not without the previous consent in writing of the government to use or permit the use of the building or buildings that may during the said terms be erected on the demised land for any purpose other than residential purpose. When it is so clearly there on the lease itself, which is the mother document, after that, whatever the petitioner says, as per my humble submission, Your Lordship, does not hold stead.
So who is the authority to give permission? The municipality.
Since the lease mentions that specifications previously approved by municipal authority, it can be presumed that the municipal authority is one of the authorities. And now his certificate, which he is showing,
yes,
as I showed, Your Lordship, the date of the certificate. So that is an afterthought. Only after filing the writ petition, he has realized, because that is in our AO. That is why they took time to file the exception also. They took time to file the exception. They went to the municipality, applied for permission. Now they've come back saying that we have applied for permission. But check the date, Your Lordship. Intention will be very clear.
Yes. So what is the status of new vacancy?
The new vacancy status, I am not updated about it, Lordship. I'll be very candid, very honest. If Lordship so wants, I will get further instruction on what is happening to the new vacancy.
Now, therefore, my lord, my application only rejected on the ground. My conversation take place after filing my writ petition. That is not the case.
No, your document says it is dated.
No, my lord. This document is generated.
Report generated on.
Report generated.
When you receive this?
I have been submit before this authority on 7th May 2025. Page 7.
And when was the inquiry?
Before my rejection.
Correct the date of inquiry.
But they are not considered your.
No. Director did not consider that. I've been asking by the SC base whether I converted or not. That's why after that I did
not submit all
submitted the documents.
Did you submit this document with this list of applications?
Page 8, my lord, I generated.
This letter you have considered your authority.
I generated, my lord. Authority have been issued me on 26. That does not mean I have been approved on 26.
That is on 7th of May 2025. You have submitted this document.
Yes, my lord. And my rejection on 14th May by the director. Director did not consider that. Only my rejection, my Godown situated in a residential plot.
Residential building.
Residential building. Yes. Now, my lord, come to page 42 of the writ petition.
What is this document?
RTI.
No, page 42, my lord.
Page 42.
These dealership also running in residential building.
That is altogether separate issue. I do not know what is the status of the building like that. Your building has a status of residential purpose. Used
My
by
lord,
the-
this building was
One
residential
small
status.
submission, Lordship, that is what he is saying continuously, somebody else, that I really don't know. I will have to get
Yes, that is
information
some-
about somebody else.
I
But
have
one
not made the
wrong
point.
does not give
But
the
my
petitioner the right
friend says
to
so I
execute
place it.
another wrong.
Very well. I am disposing of the writ petition, directing the authority to again consider his representation again
My lord,
later.
in similar circular says, secretary passed an order.
Provided,
DD, director DDPs.
No, director DTP has rejected my application.
So director DDPs has to consider it.
Because my lord, similar circular says secretary passed an order, your lordship affirm this order.
Whatever may be, director
all
DDPs
right,
is out.
all right.
Please
Lordship,
take down.
kindly, when you pass such order, Lordship, kindly also consider that we have not yet been able to make any submission regarding what is the status of that vacancy.
Yes, yes.
In case they have proceeded already or something, then that should also be taken into consideration.
Petition applied for license of FPS in terms of notification dated 15/5/2024 issued by the SCFS Kolani. After complying with all formalities, the application of the petitioner was rejected on the ground that, as per lease deed, the proposed shop cum godown of the petitioner is situated over a building which can only used for residential purpose. Thus, it is the view of the state respondent that the property is not suitable for running FPS. Petitioner has challenged the decision of the authority on the ground that the said residential house has already been converted for commercial purpose by an order of the Kolani municipality. Full stop. He placed the document with the concerned SCFS before cancellation of his candidature. Such representation stroke letter dated 7th of May 2025 of the petitioner was not considered. It is the contention of the petitioner that the petitioner candidature was wrongfully and malafidely rejected by the authority. So he prayed for necessary order of mandamus. Necessary mandamus, order of mandamus upon the respondent authority. Full stop. State authority challenged the writ petition by filing an affidavit in opposition. It is the contention of the state authority that in terms of the vacancy, the petitioner has applied for license showing the proposed godown location at A/7 145, ward number 13, village Kondani under PO and PS Kolani, district Nadia. On perusal of the lease agreement in respect of the above mentioned godown location, it appears that a lease was executed between governor of West Bengal and the father of the petitioner on 7th of March 1995. In the said agreement, clause 4 has stated, has inter alia stipulated that, quote, to erect, construct and complete buildings for being used for residential purposes. clause 10 of the said lease agreement further stipulates, quote, not without the previous consent in writing of the government to use or permit to use the building or buildings that may during the said terms be erected on the demised land for any purpose other than residential purpose, unquote. Learned counsel for the state authority submits that this being the stipulation in the deed itself, it is not possible for the authority concerned to allow the petitioner to run a FPS business over the said residential building. It is the further contention of the state authority that the concern, it is the further contention of learned counsel for the state that concerned state authority, after careful consideration of the lease deed, has rightly challenged the rightly rejected the candidature of the petitioner. Full stop. Having heard the learned counsel for the parties, also considering the lease deed executed between the father of the petitioner and the governor of West Bengal, it is true that without permission of the state authority, the use of the building cannot be the building cannot be used for commercial purpose. However, the petitioner has placed a document wherein it appears that the necessary permission has already been obtained by the petitioner to use the said building as commercial purpose, which he has placed with the authority on through a letter dated 7th of May 2025. It appears that the authority concerned has not considered this document before taking the appropriate decision. At this juncture, I think the matter should be relegated to the concerned Director DDPS, being respondent number 3 of the instant petition, to reconsider.
Keeping in mind, Lordship, what we have submitted in F, paragraph F.
Okay.
Was rejected.
Okay.
And consequently, vacancy for is re-notified, vide memo number. And rejection was before he submitted this municipality document, Lordship. That also.
To reconsider the candidature of the petitioner in terms of his letter dated 7/5/2025, along with the document of conversion issued by the Kolani municipality. Full stop. I make it clear that the state has already reported that earlier vacancy was rejected due to ineligibility of any candidate, and new vacancy has been re-notified. But it appears that if the candidature of the petitioner appears to be fulfill all the criteria, it is not necessary to take the all recourse for re-notified the vacancy again. On the same observation, the steps taken by the respondent authority regarding regarding re-notification of the vacancy be hereby stalled till the decision be obtained. Decision will be taken in respect of the candidature of the present petitioner in terms of the document issued by the Kolani municipality in his favor.
And consideration in accordance with law, Lordship,
Yes.
because that is the only
Under the
one
above observation, the instant
document.
writ
What
petition be
other
disposed of
documents?
with a direction to the petitioner to submit a detailed representation to the concerned respondent number 3, coupled with the document as mentioned here in above, with to the respondent number 3 within 2 weeks from the date of passing of this order. On such representation, the respondent number 3 shall dispose of the representation according to law, after giving a reasonable opportunity of being heard to the petitioner within 6 weeks from the date of receiving of such representation. The decision of the authority should be communicated to the petitioner within 2 weeks thereafter. Yes.
Humble submission, Lordship. Instead of saying being stalled till disposal of his.
Yes,
because
that is that.
Yes, in case he is not approved still.
Stall till the decision of the authority.
Yes.
I make it clear that this court has not entered into the merit of this matter. The respondent number 3 shall dispose of the representation according to law without being observed, without being influenced by any observation of this court.
Grateful, Lordship.
Next.
My Lord, I am for the petitioner. Initially, my Lord heard the matter on 28 July 2025 and directed the state advocate to file a report.
Mr. Suman Sengupta today is under disposition. He is physically not fit. Let it not this week. Not this week. Next.
I am for the state.
And I am for the petitioner, Madam. I am challenging an order passed by the state authorities by which my application for FPS license has been rejected on 2 grounds. Firstly, my Lord, it has been alleged that I don't have financial solvency. I have documents to that effect that I have. Secondly, my Lord, it has been stated that my plinth height does not satisfy the eligibility criteria, which is not proper. I'll just come to the order first and I'll show that these are perverse. The order is at page 85, my Lord.
Yes.
This was earlier, there was a direction by your Lordship to reconsider my case, and pursuant to that reconsideration, this order has been passed. May I read out, Madam? The relevant portion is at the 2nd page, the last paragraph.
Yes.
Whereas in light of the scrutiny of findings of inquiry report of the I am of the considered opinion that application of the petitioner in respect of vacancy number such and such was rejected due to non-fulfillment of financial solvency criteria as contained in the order, my Lord, the 2013 order, and very narrow entrance. Firstly, narrow entrance is not in the eligibility criteria. I'll just show that. And insufficient plinth height. So three criteria. One is non-fulfillment of financial criteria. I'll just show the eligibility criteria from their own notification. I'll show that I have the eligibility criteria. My Lord will kindly take up the notification, which is at page 24, my Lord. My Lord will kindly take up page 25, which is the relevant portion. My Lord will kindly come to numerical 8, Roman 7. This deals with the financial solvency criteria, my Lord.
Where is this page?
Page 25, my Lord.
25.
Part of the notification, numerical 8, Roman 7.
Yes.
Working capital or fund requirement at the time of application. Applicants for dealership must have a bank balance of 50,000 in the form of savings account, current account, or fixed. I will kindly note this, or fixed. The word used is and/or, not and. Fixed term flexi deposit in a scheduled commercial bank or a post office as a working capital on the date of application. Now I'll show the date of my application. The application receipt is at page 40. I will see this application has been made on 5th April 2024. That is at page 40.
Yes.
So I have to show that as on 5th April 2024, I had a bank balance of 50,000 either in the savings bank account or as a fixed deposit. I have a fixed deposit of more than 50,000 that I can show, that is at page 39 as on that date.
What you have stated in your application regarding the bank account?
But application I've stated the application is online, so I could not have annexed it.
You in the online there is a form.
There's an online and I've
the form stated what is your bank account.
Yes,
What you have stated in the bank account.
I have to state that my bank account has sufficient balance.
Yes.
But this is an online form, so I could not have annexed it, my lord. Page 39, if my lord kindly comes to.
Where is the copy of online form?
My receipt is there, my lord, but the online form, my lord, it is submitted, so now I can't take a printout. Once I submit the application, I can't take a printout now. At that relevant point of time, I did not take a printout, but now since it's submitted, I cannot take a copy of the same. That is the difficulty. But as on that date, I have the fixed deposit, and this was part of the earlier writ petition also. This is not a new document. Page 39, my lord, will see, kindly see the date of the fixed deposit. This is 23rd December 2022. And how many days it is valid, my lord? This is of 7 years. So I have a fixed deposit of 2022, which is valid till 2029. I participate in the year 2024. So I have a bank account balance of more than 50,000. In fact, it's a fixed deposit of 2 lakhs. So, my lord, this contention that I don't satisfy the financial solvency criteria is completely perverse. Now I'll come to the next round of rejection, my lord, if my lord deems fit.
Yes.
The next round of rejection is very narrow entrance. I will kindly come to page 86. Second paragraph. First is non-fulfillment of financial solvency criteria. Second is very narrow entrance. So the words very narrow entrance or something very similar has to be there in the notification. And if that is an eligibility criteria, only then can I be rejected on that. The notification is at page 24. The relevant portion is at page 25, eligibility criteria. I will kindly see a table which has a heading for Panchayat area. It must have a space of minimum 300 square feet along with a covered space of 100 square feet adjacent to the Godown to be used for office purpose for weighing and EPOS operations. Total number of compartments for shop and Godown should not exceed 3 and should be adjacent connected to each other. However, if the Godown and shop are accommodated in a single compartment, the area should be minimum of 400 square feet. Next, the Godown should be well ventilated pakka structure having roof of concrete slab, brick slab or asbestos sheet having bituminous coating and cemented tiled floors. Minimum height of the Godown should be 2.43 meters along with sidewalk. Plinth level should be 0.6 meters from the road level or ground level. A veranda with shade.
Yes, I have seen it.
So there is nothing.
Whether these grounds or your challenge can be ascertained without report.
That will
you have the report.
No, my lord, there is no such direction, my lord. I shall, my lord,
produce the inquiry report, my lord, and my lord, his application if available, because those two documents are relevant, my lord, for the purpose of adjudicating this. Kindly give a direction. I shall file a short affidavit or a report in the form of affidavit.
Very good. Please take down. Petitioner challenge.
My affidavit of service may be taken.
Affidavit is filed on the petitioner is taken on record. Petitioner challenge an order of concerned authority dated, the region order of concerned authority dated 8th of May 2025, whereby the subdivision controller concerned has de-approved the selection. No. Has cancelled the candidature of the petitioner on basically 3 grounds. That is, 1, petitioner was not financial solvent at the date of filing application. 2, there is a very narrow entrance to approach the proposed shop come Godown of the petitioner. 3, insufficient plinth height. Full stop. Granted counsel for the petitioner submits that the order itself is perverse. The petitioner had sufficient bank balance or financial capabilities at the day of filing of the application. The concerned authority has erroneously not considered the second. Having heard the learned counsel for the parties, it appears that the writ petition can be disposed of effectively without giving an opportunity of the respondent authority to file a report. Let a report in the form of affidavit be placed on record by the respondent authority within 2 weeks. Reply, if any, by the petitioner. Reply, stroke exception, if any, by the petitioner within 1 week thereafter. List the matter on 16th of September 2025 under the same heading.
I'm grateful, my lord.
Grateful. Next.
In this way, I apply for the petitioner.
Yes.
I have served that. But the petition number 1 is a registered partnership firm and represented by its partner. Petition number 2 is the partner of the petition number 1. The petitioner, my lord, is a general contractor and carrying on business of construction of government works and having his reputation in the market. But the respondent authority, IOCL, Indian Oil Corporation Limited, floated a tender. Petitioner offered a quotation. Petitioner's quotation was accepted and letter of intent was issued to the petitioner. Subsequently, work order was issued to the petitioner. And the work is replacement of 5 numbers tank.
Yes.
Replacement of 5 number existing tank, oil tank, in place of new tank, with new tank. And the tank should be supplied by the IOCL. And the work should be completed within 24 weeks from the date of hand over the site to the petitioner. And the petitioner started works, and the petitioner completed 2 number tanks, installed 2 number tanks, but during the installation of 2 number tanks, the water was engaged from the outside wall, and the water was filled up in the pit of the tank. Due to this reason, the work was completed. Installation of time of installation of 2 number tanks was in late. Subsequently, number 3 tanks, they did not allow the number 3 tanks, but that was allowed subsequently. For this reason, the petitioner could not complete the work within 24 weeks. The petitioner, prior to this, petitioner made application for extension of the time to complete the work. And also not only that, installation of 5 number tags along with the additional work is construction of new building of the petrol pump. That was added subsequently. But they did not extend the time. Several representation was made to the respondent authority, but did not give any response to that. Subsequently, work order was show cause was issued to the petitioner. Petitioner replied to the show cause, and work order was subsequently work order was cancelled. And thereafter, show cause issued to the petitioner. Why he should not be placed on holiday listing. The petitioner made a representation. Petitioner replied to the show cause, and the subsequently petitioner was replaced on holiday listing. And there are holiday listing. Work order was cancelled, and petitioner was blacklisted by the IOCL. Petitioner's last of all, petitioner made a representation for cancel the order of work order and also the holiday listing. So they did not give any response to the petitioners. Last representation annexure P6. Annexure P6 page 92. And subsequently offered for another tender, but they participated in another tender, but they cancelled on technical issues. On the ground, the petitioner was on holiday listing. Raise and rebuild of Uma service station at Godiahat. The work is within time. And also they did not, geophysical test was done by the authority before hand over the site of the tank to the petitioner. Yes. And in terms of the work orders, that was mandatory. My lord?
We don't do that.
No. We could not. I was debarred to complete the work because of time was not extended. Inspector made several representations within time. Back to work. Yes. We have visited thereafter. My lord, I don't know when the excavation was going on. The water was increased from the outside wall. And water was filled up in the tank. But the authority did not test the soil. They did not conduct the geophysical survey, which is mandatory.
Now, kindly sees this case where if kindly sees the termination order. It's a detailed termination order. Before the termination, a show cause was issued. In the show cause, the allegations, the breach on the part of the petitioner was pointed out and an explanation was sought for. In response to that, an explanation was given. Considering that explanation,
Yes.
a detailed termination order has been passed. Now, Manat, can you see the termination order is at page?
Page, my lord.
Page 71.
P4, Annex P4. Yes.
And several emails, several letters were issued, all were referred. Several emails were issued, several meetings were held, several chances were given to the petitioner to complete the work within time. And kindly appreciate it's a case of running petrol pump. At a running petrol pump, certain construction works to be carried out. Now the entire job specification, the terms, everything were there in the tender documents. Accepting all the tender terms, the timeline, and each and every condition, the petitioner participated in the tender. Accordingly, the contract was awarded. Site visit, all the testing of the soils, all were done. All were done. And those are all part of the tender documents. Upon satisfaction of these tender terms, upon satisfaction of the job requirement, the site requirement, the petitioner participated in the contract. And several opportunities, it's not the case that immediately after the initial timeline, the contract was terminated. It's not a case. Kindly see the date. Kindly see the date and the petitioner wants. Page para 7 in the petition, page 4. The work orders was issued on 7th of February 2024. Para 6. Page 4. The work order was issued on 7th of February 2024. Now, according to the petitioner's own admission, para 7, petitioners, it was mentioned in the work order that the contractual work will be completed within 24 weeks.
Yes.
From the commencement of the work. Now, according to the completion date, according to the petition, is 14th of August 2024. Now, if you notice, kindly see when the termination was issued. Before the termination, a so cause notice was issued. The so cause notice has been referred. He has not annexed the so cause notice. The so cause notice has been referred in the termination order.
Yes.
Termination order has been issued on 25th of September 2024.
What are you pay for it, sir?
Kindly see page 72. As on the original completion time, what was the percentage of work that was done? Kindly see second para at page 72 of the termination order. As on 1st August 2024, with just 1 week remaining until the contractual completion date of August 8, 2024, the overall job execution stood at 5 to 6% only. The works of handed over first page have not been completed. Even the first page has not been completed. The petitioner's claim is in respect of the other phases, but even the first phase has not been completed, which have been tabulated in notice dated 1st August 2024. From for further phases could not be handed over due to inability of the contractor to complete first phase, because it has to be done phase wise. Otherwise, the running petrol pump, a part has to be done first. Thereafter, the work for the next part has to be executed, so that the spaces can be made free. Now, all these, several emails were issued, several letters were issued. Thereafter, meetings were also held. Kindly see all the reference of the meetings were also pointed out. and each and every point which the petitioner is alleging as to the cause for non-completion within time, all the points were equally dealt with. Each and every issues were dealt with and referring to the general conditions of the contract. All the terms and conditions were referred in dealing with the reply of the petitioner. Now, in a read jurisdiction, the petitioner cannot come up and say all these reasons are incorrect. Then it has to be proved. Analysis, the minutes of the meetings are also referred. Meeting was held on 25th of June 2024, page 73, second paragraph. Even in that meeting also, the petitioner gave assurances. The special terms and all the conditions of the special terms and conditions of the contract were referred. Even the general conditions of contract were referred. What all clauses were being violated. Now kindly see immediately the second last paragraph of that page 74. Each and every explanations of the petitioner was duly considered and replied to. And not only that, the tender conditions in while giving reply to the explanations were also placed. Page 74, last paragraph. Clause 19 of the general conditions of the tender has been placed. Now all these are part of the job. Bailing out water from underground, then shoring. Even the general conditions of the contract specifically says in clause 4.2.20, the execution of the work shall entail working in all seasons, including monsoons. All the work conditions were well within the knowledge of the petitioner. Clause 4.2.2.1 has been referred, under which the contractor shall also arrange and bring to each job site such special equipment and machinery as may be necessary to enable work during the monsoon, and shall at his own cost and initiative arrange at all times for dewatering the job sites so as to keep the construction site and areas to be worked upon free of water.
Like the petitioner.
Several speech which has been discussed. Kindly see onto the last paragraph of at page 74, 75. There are several breaches on the part of the petition. Now, after termination, this termination took place in September 2024. And this writ petition has been filed in May May 2025, challenging the termination. And after termination, the kindly see page 75 under the contract also in the as per the general conditions of contract. Upon termination, the balance work can be completed at his risk and cost through a third party contract. That was also done. Page 76, kindly see last paragraph, page 76.
But I have invested huge amount. I have deposited security deposit. Malad, with my ill intention, why I should
now kindly see not only
keep that
that,
work
page
incomplete?
77 after
So I am asking.
After termination, page 77 of kindly also says this is as per the contract. Because after termination, a joint measurement has to be done. Like for the work which the petitioner has already completed under the contract in question, to measure that work after termination as per the contract terms, a joint measurement has to be done also, so as to clear the running account bills. Now that was also called for second last paragraph at page 77. This is as per the contract terms. Clause 7.2.20 of the GCC, Sharda Council hereby also informed that survey and measurement of the works performed under the contract up to the date shall be conducted on 30th September 2025. The petitioner did not appear.
No, he appeared. The Indian Oil Corporation did not appear. All right, his work was cancelled.
After
He has
this, my
been,
lord,
he has
there
been
is a
placed on
provision
holiday
in
listing,
there is a
and his
provision
livelihood has been snatched by the IOCL.
the provision in the general conditions of contract also, which is also seen in other matters, whereunder in case there is a case of breach and accordingly the contract stands terminated, then the employer concerned has a right as per the policy to blacklist that particular person. However, before blacklisting, a SOCA is also given. A SOCA's notice is also given. That is also there. The SOCA's notice has been given at page 87, 11th March 2025. This SOCA's notice is in respect of blacklisting. As holiday.
Holiday list.
It's banned. In the policy, it has been termed as a holiday list.
To participate in any other bid.
Now, we'll also
Well, my livelihood has been snatched by the IOCL Limited.
Page 88 here in this by of a tabular statement, the allegations, petitioner's reply, and thereafter the decision of the corporation. It has all everything has been mentioned in detail. These are not only breach of the tender terms, and if these are to be evaluated, then evidence has to be laid out. Who is saying correct? These are all facts. The contract has not been annexed. That I have to check. There must be. I have to place that then, because it has not been annexed.
But contract
The
has been
general
terminated.
conditions of
Contract terminated.
general conditions of contract in there it is mentioned, because if in the termination also the certain clauses of the general conditions of contract and the special conditions of contract have been relied upon. So those are not annexed. So I have to place that.
Well, a contract has been terminated, so that arbitration there is no value arbitration clause.
Grants me time, then tomorrow I can place the conditions of contract.
No, my lord. Due to the act of God, I could not, my lord, I could not complete the job within time, my lord, due to the act of God. Due to the water, my lord,
Additional work, additional.
and subsequently additional work was added. My lord, no, my lord, two number tanks was replaced, and it was clip time due to the ingress of water from the outside wall. This is the reason. And I made application within time for extension of time, but they did not respond. Within time, I made application. Page 3, Annex P3, my lord.
The representation which was placed before your lordship, kindly sees the date. It was after the termination.
But that was after the termination. Annex P3.
Even as on the
My
date
lord,
of
my lord, the work order was been terminated, but petitioner has been placed on holiday listing. That cannot be done. Well, I should not be debarred to take part any other bit.
express tender was it was floated for the balance work at his risk and cost. That was also done. I have got documents also. The work orders were also issued.
করেছে বলেছিল যে ব্যালেন্স ওয়ার্কটা করো না holiday listing, that was my livelihood has been snatched by the IOCL Limited. I have been debarred to take part. I have deposited security amount, and subsequently I invested huge amount. And
completion.
RA was not released by the IOCL Limited to me. I have yes. But I shall complete the job. I am not given any opportunity. I am not given any opportunity to complete the work. No. But holiday, I should not be placed on holiday listing because my livelihood would be jeopardized. My lord. Later, on that part, my lord, your lordship kindly consider because I should not be debarred.
It's the part of the contract. We cannot. It's
any other bit.
It is a part of the contract. The contractual term says in case of breach of the termination.
Act of I could not complete the work.
The tender, there has been detailed termination order. The holiday list.
No. Let the yes, my lord. You have.
No, that I have to check. Because the general conditions is not annexed. I can place it instead of report tomorrow itself. I can place it. Kindly keep the matter tomorrow. I tomorrow itself I can place it.
ঠিক আছে প্লেস করুন অসুবিধা কি আছে আমি
এটা ভালো দেয়া
নেবেন না আজকে 11
What
7, 27 February. 7 February. 7 February. 7 February. না না ওই ইস্যু করেছে ঠিক আছে
11th March 2025.
Page
Page 87.
page 87. What 2020?
submission.
কোন তারিখে 19 কখন বলবো হ্যাঁ মানে মানে ক্যান বি ফিক্সড অন 20th or 20th
अगस्त बोल
20th
अगस्त
My lord, one indulgence, my lord. My lord, one indulgence, my lord. In item number 67, my lord. And at the time of call, my lord, I was in court number 8, and could not appear, my lord. Item 67, Mr. Huda is appearing for the petitioner.
Let
My lord, probably, my lord, there is a further direction for filing affidavit, my lord. Affidavit is ready, my lord. And may I file? Yes, yes, already served.
That's there in the order, my lord, but he used to file it before the court. That is what he used.
May I file, my lord?
Yes,
Yes, yes.
We received it on Friday.
Sixty-seven, item 67.
We had received it on Friday, my lord. It's getting affirmed today and it will be fine.
Affidavit din.
Grateful, my lord.
With my lord's kind indulgence, my lord. With my lord's kind indulgence, my lord, my learned senior friend is appearing for the petitioner, item 80, 81, and 249. My lord, these three writ petitions, my lord, it's covered by the judgment wherein my lord has passed regarding transfer of customers, my lord, of LPG distributors. My lord, it's covered completely by the judgment which my lord has passed. Only there are just 7 or 8 words in the judgment which my lord I am just have taken instructions which are not correct. So my lord, it's just half a minute which will be taking, or rather 1.5 minutes.
Because
So
he will not be available tomorrow and day after tomorrow. Otherwise, we shall suffer also.
if my lord keeps it at takes it anytime at 2 p.m. also today, my lord, will 1.5 minutes or 2 minutes maximum, my lord. Item 80. Are কোনটা 249 তাই তো?
সব লোকে আছে আরো ফাইল হবে
না এই দাও, দাও।
প্রচুর ফাইল হবে টেনশন নেই
না ওটা হবে না।
কি না ওপিতে ভালো হবে না না ওপিতে for 10 days, your lordship fixed the matters. So all together now coming. So if you can we come back at 2 p.m. my lord? Only it will take my lord not more than 3 minutes.
Item 80, 81, and 249, my lord.
Same all. At 2 p.m.
Today at 2 p.m.
Today at 2 p.m. ঠিক আছে থাকবে না এখন বসে থাক বেশ
Deeply obliged, my lord.
থাকিস
My lord, item number 1 to 5, Mr. Oren Banerjee is appearing for the opposite parties, and due to some personal difficulty, he has left the court, my lord. My lord, kindly make it not today, just. And my lord, item number 91 is similar to these matters, my lord. Caveat has been filed, but no copy has been served upon
We
us.
served, your lordship. We served upon them.
পাইনি তো স্যার কখন আজকেই গেছেন
না তো
মানে একদম ইয়েকে দিয়েছেন ভেস্টা টাইম কোম্পানিকে দিয়েছেন
তোমাদেরকে দিয়েছি My lord, they are proceeding before the learned executing court. They filed an application under order 41. Tomorrow. Yes, lordship. Very short point. It won't take much. Yes, lordship. Yes, lordship. All right, lordship. 1 to 5 and 91. 1 to 5 and 91. Yes.
Challenging the show cause, they filed a reply.
The show cause notice has been challenged and the reply was given. And pursuant to giving hearing and all, the penalty of 10,000 has been imposed. So this petition,
They challenged the show cause notice.
only the show cause notice was challenged, yes, after giving reply. Now the reply was considered, hearing was given, and a penalty of 10,000 has been imposed. I think the petition has become infructuous. Show cause notice at page 36. imposing penalty of rupees 10,000. Very well. Mr. Zempa.
Lordship, I am for the state lordship.
I am appealing on behalf of the private respondent. Against whom?
Two times they are taking not today, lordship. Two times. Even next Wednesday, previous Wednesday also, lordship.
There were several persons in the frame at that point of time. While the several persons in the frame while the dealership got vacant. During the vacancy, I also applied. The 7 persons also applied, my lord. In that, I was a successful candidate. I am running that dealership shop now. Now, petitioner challenge, yes, my lord.
Lordship, they are not showing, petition does not showing his Godown, lordship. That's. He said, lordship, what of the time that his land is not conversant of his private respondent, lordship. And that is one of the basic things, lordship, they are not, petition does not showing his Godown, lordship. When they go, getting the investigation, lordship, petition does not showing his Godown. That's Godown is lock and key, lordship, that time. You should kindly see the instruction, lordship.
Since April, I have been running, my lord. Since
চলছে
কি করলো কি করলো
my lord, I am for the petition. My affidavit of service. This matter, what happened, my lord? On 10th May 2024, the subdivision of controller food and supply, Kharagpur subdivision issued a vacancy notice for appointment of fair price shopkeeper. And see the notice at page 15. In terms of the said notice, the petitioner made an application or against the said vacancy. That is that copy of the acknowledgement of the petitioner's application, that is at page 19. Thereafter, the district court issued a notice of inquiry. The petitioner, regarding after conducting inquiry, issued a notice for personal interview, that is at page 20, annexure P3. Thereafter, the petitioner learned that the responding authority selected the respondent number 8, who has who has no Godown at all, because at the time of inquiry, he has shown Godown, alleged Godown, which is situated on the government land. The petitioner raised objection against the said Godown. On the basis of objection, the respondent authority directed him to demolish the portion of the Godown, which is, and remove the same, but subsequently selected him. That is, at the time of inquiry, the Godown situated on the government land, and clarify the notification, that is, kindly come to page 16, part 2. Objection I
I have made a statement, but the copy
No,
of
sir,
the
representation is
petition was not given, a receipt copy was not given to the petitioner. No, but that was not given. Apart from that, kindly see the nature of the land.
That was converted, my so far my instruction is concerned, the land was converted, my
And their area is.
and regarding the Godown is concerned, let my senior man conclude then I.
Record of rights. No license has yet been given.
Yes, my lord. License has been given, allotment also. Yes, already done.
File the report. I want to show.
And my lord, the so far my instruction is concerned, the Godown is constructed on his own land, my lord. We wrote a letter to the BLLRO and he's in for the information from the BLLRO getting this, that land is belongs to the private respondent.
Report from.
No.
ক্যান্সেল করবো ওটা
Yes.
Yes. Every service.
He has, my lord. He has. Apart from that, the character of the land is jol. That is the water body. How? Jol.
Is not even recommended, my lord.
জানা কেন করছে
Three weeks, my lord. Lordship was pleased to direct the affidavit in opposition. Grateful, my lord. Grateful, my lord. Great.
5 weeks.
My lord, I have come up with a innocuous prayer, my lord, to obtain leave and file it on urgent basis, lordship. No, again, lordship, this notification has been issued by the district controller asking the MR dealer to get the stock for the month of October, lordship. Now, there is already held by this honorable court of this honorable judges of this court, lordship, that the stock will be 45 days, limited to the 45 days, lordship. So far, the capacity of the Godown is concerned of the MR dealer, lordship, they cannot hold the stock more than 45 days, lordship. Now, the notification has been issued by the district controller. They are asking to gain the capacity for the October
since the October, Lordship. We are on August, Lordship. They are forcing us to take the food grain to distribute in October, Lordship. That is the difficulty, Lordship. If there is some urgency in this matter, Lordship. Yes, Your Lordship. I don't have the space to take all those stocks, Lordship. On Wednesday, Lordship.
Malad ke restore. Malad kind.
Full Your Lordship.
Restore malad. Yes.
Wednesday.
Malad kind.
Malad 70.
Malad 72, 73 malad kind.
2 PM fixed matter আছে Milord,
Malad kindly malad I.
Malord 75 next matter Milord with the no but exception Milord,
The matter
exception we shall file. Your Lordship can record exception we shall file. Then Your Lordship kindly fix the matter in another.
malad 72, 73 malad kindly kind.
Future.
My lord, item number 72 and 73, my lord, your lordship directed my lord dismiss for default, my lord.
No, no, not dismiss for default. Item number 72, your lordship has passed an order, my lord, dismissing the repetition as for non-prosecution. My learned friend was not there. So therefore, my lord,
My lord, this is not true, my lord. Regarding one matter, your lordship decided the issue, and that was, my lord, final order has been passed. Regarding this, my lord, this FPS dealership, my lord, no final order has been passed. My lord, so cause notice has been given. I filed reply that is pending before the adjudication. For that reason, my lord, I filed before your lordship on writ application. That was not, this writ application was not, my lord, became infractuous.
72.
72.
72, they have said the order has already passed.
for my instruction, my lord, I
Order
have,
has
we have,
already
we
been
have,
passed.
but now I have come to know from my learned friend that there are two FPS, two writ petition, but the same petitioner. Might be there is some confusion. Therefore, now they are praying for recalling of that order since they were not there at the time of calling my lord. My lord may kindly fix the matter any day. Let me come with the proper inspection. Let them proceed with their matter.
So cause notice has been given. I filed reply, not decided till.
File recalling application, madam.
My lord, kindly, my lord, two matter, my lord, my
No, no,
learned
like
friend
that.
73, private respondent present lordship.
Yes,
Private
private respondent was present.
lordship.
How can I file?
My lord, kindly, my lord.
No, 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 not like that. No, 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 madam. You know the rule. Otherwise, private respondent will come and say how the recall has been done.
Have notice to my learned.
Serve notice. You serve notice.
Notice already served, my lord.
No, no, private respondent was there.
See, Alada.
He was there.
73, item number
70 to 72 both.
73 lordship.
72, no, 73.
You file application, otherwise you will difficult. No, no, no. Call list.
Kindly.
No, no. Why 7? Okay.
Hundred and five, take 2 minutes, my lord, the extension of time.
Then.
100, my lord, deeply grateful, my lord. My lord will kindly come to my lord's order at page 10, my lord.
What is your application? No application is there.
Our application, it's there, can 2 of 2025? Can 2 file in?
105 can 2.
Can 2?
Can 2 din.
11 জুলাই ফাইল হয়েছে 11 জুলাই
এটা can 2 না তো MV.
It's there in my lord's file.
No.
11 জুলাই এসে গেছে কোর্টে আছে my lord will take my copy my lord এটা একটু my lord কে দিন তো এই যে এটা 11 জুলাই My lord will kindly see page 10, my lord, of my lord's order. This case is basically an ex parte order was passed against the insurance company, and we had filed our written statement over there that was accepted. So the tribunal, my lord's order has my lord found it page 10.
What do you want?
My lord, I want extension. My lord will kindly now see the page 11, my lord. My lord's order. I want extension of that time. My lord had granted us 6 weeks time, my lord.
Please take down. Can 2 of 2025. The application is not in the is running in the list, but not appearing in the file. This court take assistance of the learned counsel for the applicant. Learned counsel for the Bajaj Alliance General Insurance Company to take the office copy of can application to dispose of the same. It appears from the order dated 13th of May 2024 that this court directed the insurance company to deposit the cost as directed by the learned tribunal to file the and file an appropriate application for setting aside ex parte order. The insurance company is directed to prefer such application within 6 weeks.
Yes, there was a delay, my lord. We filed it, but there was a delay.
6 weeks from the date of passing of that order. It is the contention of the learned counsel for the insurance company that though they have filed the application, but there are some delay. Full stop. The delay are unintentional and purely official purpose, purely for official purpose. So they sought for liberty from this court so that the application filed by them before the learned tribunal be accepted.
And the cost also, my lord will kindly allow us to deposit that cost.
Along with the cost,
Cost of 5,000.
Be accepted by the learned tribunal. Having heard the learned counsel for the petitioner, also considering the grounds mentioned in the body of application being Can 2 of 2025, it appears to me that the learned tribunal was directed. It appears to me that the insurance company is directed to submit the cost along with the applications, though they have filed the same, but it was filed in delay. Though they have filed the same, but it was filed in delay. Considering the appropriate ground mentioned in the, ground demonstrated in the body of the application itself, the delay in filing the application along with the cost be hereby condoned. Full stop. The learned tribunal is directed to proceed with the application in accordance with the law. Accordingly, Can 2 of 2025 is
my lord will deposit the cost within. My lord will give us some time.
Deposited.
My lord,
already deposited.
No, what happened since the Section 5 application, it was filed at a later stage, after almost 22 days. So that cost was also not accepted. That check was not accepted. So we will deposit it now. My lord will grant me leave.
The insurance company is further directed to deposit the cost within 2 weeks.
3 weeks, kindly.
Again 3 weeks.
My lord, kindly, my lord. Kindly.
3 weeks from the date of passing of this order before the learned tribunal.
I'm extremely, extremely grateful, my lord. Deeply obliged. And my lord is disposing of this scan application. My lord, grateful. My lord, deeply obliged.
Call the list.
My lord, with my lord's kind leave, my lord, item 80 and 81, my lord, as we had earlier.
I will deal with this matter. Just wait.
My lord has called item 7.
Yes.
My lord, this is my lord Bose Institute matter. My lord, I appear for the petitioner since 7 to 9. My lord, we have concluded our submissions long back.
7, 8, 9.
My lord, I appear for the petitioners.
6, 7, 8, 9.
6, 7, 8, 9.
All are connected matters.
I understand.
Your lordship.
So,
6, your lordship has fixed for 13th. 13th, 13 tarikh.
My lord, may I just indicate this?
You know? Huh? So why 7, 8, 9?
Your lordship.
All are the Bose Institute matter.
Your lordship.
My lord, yes, my lord.
Item number 6 I fixed on 13th. Let both the matter appear in 13.
My lord, may I just indicate this? Your lordship, we have made our submission at length. Your lordship were kind enough to hear the petitioners, my lord. But on the last 2 occasions, my lord, I have been told, my lord, the petition, my lord, the Union of India was to make their
Union of
submission.
India supposed
My lord, for some personal bereavement, my lord, we don't stand on the way, my lord. But in the event, my lord, the Union of India is not in the position to make their submission, my lord, let the Bose Institute start the submission. The matter has been withheld for a long time.
13th, we will make our submission.
Okay.
It is free.
7, 8, 9.
Your lordship.
Separate order. Separate order. Let the matter appear in the list on 13th of August 2025.
My lord, is the time fixed, my lord? Let the time be fixed, your lordship.
Another same heading, 2 p.m. Okay.
My lord has kept it on 13th.
13.
Much obliged.
So
Next.
grateful, my lord. So grateful.
2 p.m. matter, how many?
Ten minutes, I am for the petitioner. I am led by Mr. Agarwal, madam.
But I am for the private respondent.
Which for the state? Mr. Ritesh Kumar Ganguly. Who is appearing for the private respondent?
But I am for the private respondent.
Whether you have filed exception?
Yes, Lordship. I filed my opposition since the affidavit. And I have served upon the OP and received reply also.
Affidavit in opposition file on behalf of the respondent of 5 and 6 be taken on record. Where is Mr. Ganguly? What is the matter?
This is, my lord, with regard to. My lord, I am filing
Without
my
state,
reply.
how can I proceed?
Okay.
What is this?
My lord, reply.
Then come another date, not today. Affidavit in reply by the petitioner to the affidavit in opposition on behalf of the respondent of 5 and 6 be taken on record. Affidavit in opposition 5 and 6 নিয়েছেন তার রিপ্লাইটা নেন। Affidavit in reply by the petitioner to the affidavit in opposition on behalf of the respondent 5 and 6 be taken on record. Readings complete. Let the matter appear in the list on diary. Prompt হবে 26 তারিখ। 2 p.m. 2 p.m. Twenty 25. Huh? 2 p.m. 25. 25th of August at 2 p.m.
I'm
grateful.
Next. Who is for the state? State is not appearing. Why?
Amritalal.
In this matter,
My lord, an appeal has been preferred in this matter, my lord. We have prayed for addition of party. That prayer was rejected, so my lord, we have preferred an appeal.
Is there any order of stay like that?
No, my lord, we have.
Then?
my lord, I have also filed an application for addition of party in this matter, my lord.
Where is the application?
My lord, I have mentioned this matter.
Application number
3.
Can 3.
My lord.
Can 3 is running in the list. Where is the can 3? Give me can 3. Have you served the copy?
My lord, yes. Yes, Aslam Parvez.
কোথায় can 3?
কাকে দিয়েছে? আসলাম পারভেজ।
কবে ছেড়ে দিয়েছে?
Can 2.
নিল কেন? যা কি আছে তা জানি না।
তোমার কর।
কি হচ্ছে? ক্যান গুলো যাচ্ছে কোথায়? হ্যাঁ? নেই তো কোনো ক্যান। Can 2.
Moreover, my lord, I have served the application, my lord, to Mr. Aslam Parvez. But now I coming to know from my learned friend that he has left this bit. Even then he received this. I had challenged my termination order. You'll also probably recollect. Now, in that termination, these writ petitions for several applications are being, applicants are being set up and they are filing the applications to delay. In the meantime, for the same vacancy created out of my terminations, they have initiated the process for filling up. For that, I had filed an application asking that let that process be concluded, but no appointment be given, because otherwise my writ applications will become infructuous. Now, in order to frustrate that, such applications, again, first one application has been dismissed by your lordships, again another application is being filed.
The said vacancy, my lord, his wife also made application.
Whose wife?
His petitioner's wife.
I have not
Who are
challenged
you?
the vacancy.
Who are you?
I am one of the intending candidate who
filed-
has already applied.
What is your interest here in this writ petition?
My lord, I have already applied for the
What
said
is your interest in the writ petition in
My
the
lord,
list?
The vacancy has been published. I made application. Thereafter, my lord, the inspection was also made. But, my lord, thereafter nothing has been done. I came to know from after inquiry that a writ petition is pending. As it is pending, they are not giving us a.
Is there any intimation to you that the writ petition is pending? That's why
we caused an inquiry and came to know.
Now, whether any written intimation is there?
No, there is no written instruction.
So you appear before this court to take part in the writ petition. Why? What is your interest here?
My interest, my lord,
if his writ petition is allowed or disposed of or dismissed, what is your application? What your fate will be
I have
decided?
already made an application as per the.
You file a separate writ.
I have
If you are aggrieved against the order of the or against the conduct of the respondent authority, you can file a writ. Who debarred you to file? He filed writ due to his grievances, not your grievances would be ventilated here. So if you want to ventilate your grievances to this court, you have to file a writ petition.
Then, my lord, I am withdrawing this application.
Yes, withdraw it.
Liberty to file fresh writ petition.
No liberty is there. Can 3 of 2025. This is an application filed by one. What is your name? By one Rufsana Begum.
Rufsana Begum.
By one Rufsana Begum. Having heard the during course of hearing of the instant application, learned counsel for the petitioner intends to withdraw this application. Let the application can 3 of 2025 be disposed of as not pressed without considering or passing any comment on the merit of this matter. Can 3 of 2025 merit of the writ of the instant application. Good stuff. Can 3 of 2025 is disposed of. Pick the date. Let the matter appear in the list on 27th of August 2025 at 2 p.m. for hearing.
Well, kindly, my lord, pass the interim order in my applications, because your lordship is found that they have already, my lord, processed. So if any, my lord, appointment is given, my writ petition will be infructuous. Well, let me place my case. Let him, my lord, I don't know why he is objecting to the interim order. He wants to frustrate my appointment, my lord, writ petition. Then innocuous prayer made. Let them process with the vacancy, but not to give a appointment.
My lord, my senior friend kindly proceed to the main matters, my lord.
I am ready.
Then you proceed with the.
Yes, yes.
Okay, no. In the interim, on your interim prayer,
Last occasion, my lord was
has
refused to
observed that
contain interim order, my lord.
without exchange of affidavits, no order can be passed.
No, that is in
My
the
lord,
writ petitions. Writ
Yes.
petitions exchange.
That is,
affidavits have
that is
been
my lord's
exchanged already.
observations.
Then you proceed with this order. Then,
Yes,
then,
yes.
Then we can dispose of the instant writ petition.
Now the state had come.
Yes, what is the
Well,
matter?
these entire actions, my lord, according as per the petitioners, has been taken by the subdivisional controller since the petitioner had complained of demand of, my lord, bribe by the subdivisional controller prior to, my lord, any investigation, prior to any inquiry has been made. Now, kindly first take page 27.
No, you are challenging order of termination.
Yes, yes. Because I have been, after this complaint has been made, an inquiry taken place, so-called notice, so-called hearing, then a termination order has been passed. I preferred an appeal.
Two-tier appeals are exhausted, a two-tier appeal.
Let him first submit.
No,
then
no,
my lord, I will return.
you proceed.
My lord, the appeal, first appeal.
First order passed by
By
the
the subdivision
SCFS.
contract, same persons, my lord, against whom allegations was made.
Very good. On what is the order dated?
My lord, order dated 11th of December 2023.
Order of termination 17th of October, I think. In your prayer, it is there.
Ma'am, sorry, my lord. Yes. My lord, the order is, my lord, 17th of October 2023. Bhulwal Pulchekar. Then the first appeal order of DCFS was passed on 12th of December 2023. Then final order of the DDPS, my lord, passed on 19th of March 2024. These are the three orders, my lord, under challenge.
Order dated 19th of
March 2024. Yes, yes, all. Because the initial, this was an appellate, second appellate order. Yes, my lord. Prayer E.
prayer E.
Yeah. Prayer B.
No, there is no such order.
Prayer A, it reflects 28th March. All orders have been challenged. Kindly take prayer A.
28th of March.
28th March.
28th of March.
28th of March.
28th of March is the appeal of the
Second
order of
appellate
the
authority.
order of the DDPS.
DDPS.
Okay.
All orders have been challenged. Cannot be, my lord, then writ petitions.
Yes.
Now kindly first take, my lord, page 27. Yes. This was a complaint made to the district magistrate by the petitioner. Kindly take the date, my lord, 26th of May 2023. Because we'll get it at the bottom. What said? আমি শামিউল ইসলাম পিতা আমার নিবেদন এই যে আমি একজন আপনার জেলার এমআর ডিলার দীর্ঘ 16 বছর ধরে সুস্থ ও সুন্দরভাবে রেশন তাতে কোনোদিন আমার অসুবিধা এই নতুন এসসিএফএ সায়ন বিশ্বাস যতদিন ধরে এসছেন 296 জন ডিলার আছি তার মধ্যে 12 থেকে 13 জন মান্থলি টাকা দেয় না তাই আমাকেও তাদেরকে নানা রকম হ্যারাসমেন্ট করা হচ্ছে এসিও সায়ন বিশ্বাস আমাকে বলে মাসে 2000 টাকা দিতে হবে নইলে বিল দেওয়া হবে না নানান ডিলারকে দিয়ে ওনার মদতে আমাকে হ্যারাসমেন্ট করা হচ্ছে আর মার্চ এন্ড এপ্রিল মাসের বিলের দরুন মান্থলি কাটমানি না দেওয়ার জন্য বিল আটকে রেখে দিয়েছে মহাশয়ের কাছে বিনীত নিবেদন যাতে কমিশন ঠিকঠাক দিস ওয়াজ দ্য কমপ্লেন্ট মেড অন 16th of May. Next complaint, my lord. The 16th of April, even earlier to that, it was given to page 28. So the earlier to, my lord, first complaint, second paragraph, আমার বিনীত আমি এমআর ডিলার আমার বর্তমানে আমি স্বাভাবিকভাবে ডিলারশিপ কিন্তু কান্দি মহকুমার যিনি কন্ট্রোলার আছেন তিনি আমার কাছে প্রতি মাসে নির্দিষ্ট হারা টাকা মাসোহারা দিতে হবে বলে এই দাবি করেন অন্যথায় আমার ডিলারশিপের কাজে প্রভাব পড়বে এই বলে আমাকে নানানভাবে ভয় দেখানো হচ্ছে আমার নানারূপ চাপ সৃষ্টি করছেন উক্ত টাকা দিতে আমি অস্বীকার করলে আমাকে তিনি নিজে এবং ওনার পরিচিত কার্তিক দত্ত নামে একজন ডিলার তথা ডিলারদের কথা দিয়ে আমাকে নানাভাবে হুমকি প্রকাশ করে প্রাণনাশের হুমকি দিচ্ছে আমি পরিষ্কৃত মানসিক যন্ত্রণায় আছি এবং আমার রাতে ঠিকঠাক ঘুম হচ্ছে না আমি দিস কমপ্লেন্ট ওয়াজ মেড 26th of April 2023. Then next, it was given to the secretary. Third paragraph, the earlier are same. That lodge complaint to different, nothing has been done. Now, গত 7 সেপ্টেম্বর আপনার দরবারে এই বিষয়ে লিখিত জানিয়েছি তারপর থেকে আমাকে পূর্ণচন্দ্র দত্ত ও শিবনাথ চ্যাটার্জি নামে রেশন ডিলার এসসিএফএস এর হয়ে বার্তা দেয়
যে জলে থেকে কুমিরের সাথে লড়াই করা উচিত নয়। আরো বলে তুমি কমপ্লেন করে বেড়াচ্ছ, কোনো লাভ হবে না, বড়জোর আমাকে ডিপার্টমেন্ট শোকজ করবে, আর শোকজ আমার জল খাবার, কিন্তু তোমাকে টার্মিনেট করা হবে এবং তোমার জায়গায় ভ্যাকেন্সি করা হবে, তোমার পরিবার যাতে কোনোদিন লাইসেন্স না পায় সেই ব্যবস্থা এসসিএফএস করবে। After this, my lord, an inspection was allegedly taken place. No, there was no application to police. These are serious allegations, but I had lost the his my lord, appropriate authority to the government. Yes. Now this was known to SCFS also, because they have my lord, somehow informed. Now what thereafter happened, on 26th of August 2023, this first show cause notice came. During inspections at Vishi Singho Roy and others FPS point on 24th August 2023, এটা কি first show cause notice? I'm just, may I check it? 31. It has been alleged that there is another MR dealer, there was an inspection was going on, was present there. Instead of performing the duration at his own FPS area, I allegedly hampered the inspection procedure of BC Singho and others, and also assaulted the chief inspector and ADM inspector of SCFS Kandi office. Accordingly, an FIR was lodged against me. Then, for the interest of PDS, a surprise visit has been conducted by the team consisted of ADSC, FS, CIFS, such and such. In view of the report of the above mentioned inquiry team, the following irregularities have been found. Now, kindly, Malat, see the irregularities. FPS was found closed, and he was not performing duration according to his cluster. Kindly mark here. The first is shop was closed. Then, the inspecting official contacted with his wife of the licensee Noor Jahan Khatun and her daughter Shahanara Yasmin, and the inspecting official requested them to open the door of FPS for physical verifications of PDS stocks. They told the inspecting official that the keys of the godowns are not available with them, therefore we couldn't able to ascertain the actual stock of PDS. At the time of the inspection, wife of the licensee and her daughter could not produce the original license. Who has been directed to produce his wife and daughter. Then, as per automation portal of food department, it has transpired that 0 families as on 25th of August 2023, and it is also to be mentioned that till he has 198 family is pending for distribution of food grain to ration. Then, these are the first on inspection. Then these wild allegations, the dealer has distributed less quantity of food grains to the beneficiaries, no particulars, nothing. His behavior with rationiers was very bad. Previously, the said dealer was suspended by such and such for gross violation of such and such. During the inspection of at Sandirpur village under FPS area, the beneficiaries complained that the dealer SLM does not provide entitled quantities of food grains as per government approved scale, and the dealer misbehaved with it. Now, on that basis, the gross violations of the control order such and such, now being licensing authority, the power conferred me by such and such to show cause 7 days. The second paragraph. Has you got it?
Yes.
These are the allegations. Now, this was replied to, Malar, page 33. I have received the above referred show cause notice dated such and such. Before dealing with the allegations and charges allegedly leveled against me in the said show cause notice, at the very outset, I say that although show cause notice has been issued relying on a report of the inquiring team who have visited my FPS shop, has not been supplied to me, although without consulting with such report, submission of reply in an effective manner is not possible. So first I had taken this point straight away that you did not supply me the inspections report.
Because on the basis of the report, this show cause notice was issued. Your lordship will get it from the first paragraph of the show cause notice. Now this was it. Now it is settled principle of the if any proceeding is initiated, any incumbent relying on any report, etc., it is the duty of the authority who initiate the proceeding by way of issuing show cause notice shall supply a copy of the report to the person concerned, enabling the person concerned to go through the same, so that on consultation with the said inquiry and effective manner he and she can submit his reply. Dealing with such report, rules of natural justice always suggest prescribe that the person concerned against whom allegations has been brought should be given reasonable opportunity in all possible manner to defend his or her case. But in the instant case, by way of not supplying me copy of the report, such and such, fully relying on the above statement and reserving my right of such effect, I state, although without consulting the said report of the inspection team, it is next to impossible to submit reply to the show cause in effective and purposeful manner. However, being a fair price shop owner under PDS system, I do hereby submit my reply to the show cause notice as far as is practicable without consulting such report of the inspection. Further say the said show cause notice had been issued relying on complaint of the beneficiary. However, surprisingly, such copy of the complaint has also not been supplied to me. First is report not supplied, then complaint has not been supplied. Then on 25th of August 2023 at about 2:30 p.m., an inspection team came to my shop of my fair price shop, but due to medical emergency, I went to the Sadar hospital for my medical checkup and I was compelled to close my shop on that day. Now, copy of the medical document is then closed. Has you also got it? Then I say that my fair price shop has been tagged with Nimai Chandra Das. Immediately, my lord, at the time of show cause notice, my shop was suspended. Say, what is no, sorry, my lord. I say that my fair price shop has been tagged with Nimai Chandra Das, MR distributor. Now, I say that said MR distributor always refused to provide ration articles according to my entitlement and always provide lesser quantity of the ration articles. I further say that the said MR distributor without proper measurement of the ration articles make delivery of ration articles in my shop. Or is a now doorstep delivery to the fair price shop owner by the MR distributor. By several letters, I have brought such illegal acts of the said MR distributor to the notice of the statutory authority. Copy of the some letters are enclosed. These are prior to my show cause notice. During the course of such inspection, I had never been told that any major irregularities were found in by the said team, and actually members of the said team became satisfied about my performance. In the aforesaid backdrop, with my utter shock and surprise, I have received the above paper show cause cum suspension dated such and such, where some allegations have been brought against me which are not at all true. Now, the allegation was replied, my lord. So far as the allegation number 1 is concerned, my FP was closed and I was not performing duare ration according to my cluster. I say that I always perform duare ration according to the cluster, and there was no allegations against me before this that I have not performed duare ration, but due to medical emergency, I was compelled to visit Salar Hospital, and since there was no other person to look after my FPS business, I compelled to close my shop on that date. So far as the allegation number 2 is concerned, I say that my wife is a housewife and my daughter is a school-going girl. They don't have any knowledge about functioning of fair price shop, and since due to sudden medical emergency, I was compelled to visit Salar Hospital for my treatment. The keys of my shop have been carried with me. Accordingly, my wife and my minor daughter could not able to open the door of my fair price shop. So far as the allegation number 3 is concerned, I say that I always keep original license in my fair price shop, and since the keys are lying with me and I was at Salar Hospital due to my medical, the original license could not be produced by them. So far as the allegation number 4 is concerned, I have not transacted any families on 25th August. I say that due to my medical emergency, I could not open my shop on that day. Accordingly, on that day, that was no transaction. But so far as the pending distribution of 198 family is concerned, I say that since the distribution day is up to 30th August 2023, so the rest of the 190 families can be delivered within time. However, due to suspension order issued on 26th of August, 2023, the same could not be delivered to those families, and the ration article is still lying in my shop of those 190. Till today, the tagged fair price shop owner, namely Muhammad Anarul Islam, has not yet lifted the said ration articles. On my suspension, my ration cards have been tagged with Anarul Islam. So far as the allegation number 5 is concerned, I say that I never distributed lesser quantity of food grains to my beneficiaries. I always distribute ration articles to my tagged beneficiaries according to the government scale. What more I could have replied, I don't know. So far as the allegation number 6 is concerned, I say that I never behaved badly with my beneficiaries and no complaint has ever been raised against me in this regard. So far as the allegation number 7 is concerned, I said that said proceeding was completed, finalized. As such, no reference can be made to the said proceedings. Relying on the same, I cannot be so-called referring to a concluded proceedings. But this is relating to my earlier so-called proceedings of 2000. So far as the allegation number 8 is concerned, I say that I have always delivered food grains to my all tagged beneficiaries according to the government approved scale. I never misbehaved on any. Now, I always distribute ration articles through e-post machine according to the government approved scale by providing appropriate challans to all my beneficiaries. I say that none of the consumers never made any allegations and a complaint against me with regard to getting of lesser quantity of ration articles than their scale. Rather they are very much satisfied about my performance with regard to the running of the fair. I say that during the pandemic caused by COVID-19, with all odds and lesser manpower, I have performed my duty following the instructions of the Food and Supply Department. Then closed mind, because the allegations was that I have committed. I'll again revert back to the words in the show cause notice. I say that it is settled law that the show cause notice will say alleged guilt only. However, from a perusal of the instant show cause notice, it appears that by way of issuing the show cause notice, definite conclusion has been made. From that I have committed with alleged guilt, which is no way sustainable. I hope and trust that on perusal, now before parting, last, I undertake that run my in a better manner if any guidance or instruction is fallen from your honor for smooth running a public distribution system. This was reply. Then next, page 38 is my medical document. Then page 38A. Another show cause notice. This is dated 31st of August 2023. First one dated 26th, most probably. 26th August. Now this one dated 31st August 2023. When this after suspension, when my shop has been tagged to the another FPS shop, now at that time, they found that there is some mismatch in the stock. On that basis, this second show cause notice was issued. I don't know whether it is legible in your lordship's brief. Not very legible, my lord, in my copy. In any event, my lord, these are the some shortage was detected. Again, I was asked to show cause 7 days. My lord, page 39, I had replied to it. Well, this I will be reading. Second paragraph. So far as allegation number 1 of the above mentioned notice is concerned, that the discrepancies is found in the weight of flour and rice as on 29th of August 2000. I say that my fair price shop has been tagged with Nimai Chandra Das MR distributor. The said MR distributor always refused to provide ration article according to my entitlement and always provide lesser quantity of the ration. I also that the concerned MR distributor without proper measurement make delivery of the ration in my shop. By several letters, I have brought such illegal acts of the MR distributor to the notice of the higher authority. Then I further state that no food grains were delivered to me in the month of September. This was always advance. Distributor has provided such wrong information by forging my signature. Even the e-post machine has not updated about this, which you have already verified. But they had taken into account that as if for September allotment, MR distributor had delivered. So far the allegation number 2 is concerned, no stock register and sale register available at the time of verification, but now the sale stock information is updated e-post machine, which you have already verified. It is also uploaded online on the concerned website with by the every MR dealer ID. Copy of the sales till attached. The sale register stock attached with this reply. I'll come back to annexure P5 letter, because this will be necessary. Because there is a standing government order which says that no penal actions can be taken on the basis of difference in stock. This was standing because there was system is being changed. Kindly take this page 40, dated 11th of December 2023. It is communicated to all concerned by order number such and such dated 9th June 2000 that no penalty should be imposed by the inspector staff against any FPS for difference in the book balance, physical stock balance and e-post balance stocks of food grain without verifying the figure from the department portal and consulted with the IT nodal officer of the district. The order was issued with. This is exactly what I pointed out in my reply, that it is everything is now being uploaded. So you cannot only go by the stock and sale register, and that is the exact the government order which was issued. Now
This is the standing order.
This is a standing order.
Yes.
Now, you'll also have just come back to the show cause notice. You also will find that page 31. Just once.
Yes.
The first paragraph, during the inspection at BC Singhu and others on 24th August, Samir Islam was present there. Instead of performing his own FPS area, hampered the inspection as well. Got it? This was the in the show cause notice, which triggered this show cause inspection, whatever it may be. They said that you protested there, so that is why
you assaulted.
Yes, this was the allegation. Now, on that basis, if an FIR was lost, FIR will get it on page 41.
Yes.
Same allegations. This is also untrue in any event. Page 42, I got anticipated bail in connection with the same criminal case. Page 42. But from this honorable court, passed by the Honorable Justice Devanshu Boshak and Honorable Justice Sabdar Rasidi.
Yes.
Then 44, the hearing was given. Now, what is the hearing? The question answer. Now, this is relevant. I'll be reading some of the question answer. First, 1, 2, and 3, nothing usual. Question number 5. Has you got it from
Yes.
question number 5? On 24th August 2023 তারিখে আপনার দুয়ারে রেশন করার নির্দেশ ছিল কি? উত্তর হ্যাঁ, ওদিন দুয়ারে রেশন করেছি এবং যতদিন এসেছিল রেশন দিয়েছি। দেন 24/8/2023 তারিখে আপনি কোন সময় থেকে কোন সময় পর্যন্ত দুয়ারে রেশন করেছিলেন? ওই দিন সকাল 6:30 থেকে বেলা 12টা পর্যন্ত দুয়ারে রেশন করেছি। 24/8 তারিখে একটি পরিদর্শন ছিল ভরতপুরে বিসি সিংহ অ্যান্ড আদার্স, ওই দোকানে পড়ে। এই সময় আপনি ওই স্থানে ছিলেন এবং কটার সময়? ওই দিন আমি সেখানে গিয়েছিলাম দুপুর 2:30 নাগাদ। প্রশ্ন, ওই দিন পরিদর্শনের সময় পরিদর্শনকারী দলের সদস্যদের এবং আপনার শারীরিক বা মানসিক ভাবে হেনস্থা করেছিলেন? না, আমি ওই দিন কাউকে হেনস্থা করিনি।
Yes.
Then my lord, next page. চব্বিশ 8/2023 তারিখে বিসি সিংহ অ্যান্ড আদার্স রেশন দোকানে আপনি পরিদর্শনকারী অধিকারীদের শারীরিকভাবে হেনস্থা করেন, এই অভিযোগে একটা এফআইআর করা হয় যার নাম্বার স্যার। এই বিষয়ে আপনার জানা আছে? হ্যাঁ, এফআইআরটার বিষয়ে আমি জানি। দেন এগেন 25/8/2023 তারিখে মহকুমা খাদ্য নিয়ামক কার্যালয় থেকে একটি পরিদর্শন দল আপনার রেশন দোকানে পরিদর্শনে যায়, এই বিষয়ে আপনি কি জানা আছে? হ্যাঁ, জানা আছে। সেই সময় আমি ওই পরিদর্শন দলটি যায়, সেটি রেশন দোকান খোলা থাকার সময়ের বাইরে পূর্ববর্তী কোনো নোটিশ ছাড়াই। This is important. Show the timings of the shop rooms to remain open as under the control order. In any event, on 25th of August 2000, নির্ধারিত দুয়ারে রেশন কার্যক্রম আপনি অংশগ্রহণ করেননি কেন? কন্ট্রোলারে ভয়ে আমি দুয়ারে রেশন করতে যাইনি, কারণ আগের দিন কন্ট্রোলার ভয় দেখিয়ে বলেন তোর বউকে দিয়ে চা বিক্রি করাবো। প্রশ্ন, 25/8/2023 তারিখে পরিদর্শক দল আপনার রেশন দোকানে গিয়ে আপনার স্ত্রী নুরজাহান খাতুনকে দেখা পায় এবং তাকে পরিদর্শন দল অনুরোধ করে যে আপনি রেশন দোকানটা খুলে দিন, যেহেতু আপনার স্বামী রেশন উপস্থিত নেই। রেশন আপনার জন্য স্বামীর অনুরোধ করা হচ্ছে। এই সময় আপনার স্ত্রী নুরজাহান খাতুন বলেন যে তার কাছে রেশন দোকানের চাবি নেই, সুতরাং তিনি খুলতে পারবেন না। হ্যাঁ, আমি সেদিন সালার হসপিটালে ছিলাম, পরে বিষয়টি জানতে পারি, এই বিষয়ে আমি দুঃখিত। নেক্সট পেজ। Same, whatever I have stated. The next question is license. They wanted the license from my wife. He said that yes, because the keys are not available, so that is why his wife couldn't show it. Then next question will be important. খাদ্য সরবরাহ দপ্তরের পোর্টালের তথ্য অনুযায়ী 25/8/2000 তারিখে আপনার কোনো একদিন রেশন দোকানে বিলি করা, অথচ তথ্য অনুযায়ী 198 পর্যন্ত তখনও তাদের প্রাপ্য রেশন পাননি। এই পরিদর্শনকালে আপনার প্রাপ্য রেশন বন্টন না করার কারণ কি? উক্ত দিন ক্রমাগত কন্ট্রোলার সাহেবের 50,000 টাকা চাওয়ার জন্য আমি মানসিকভাবে ভেঙে পড়ি। উক্ত রেশন দ্রব্য বন্টন করার সময় 30/8 তারিখ পর্যন্ত কিন্তু 50,000 টাকার মধ্যে 25,000 টাকা দিলেও, কাইন্ডলি নোট, 50,000 টাকার মধ্যে 25,000 টাকা দিলেও আরো 25,000 টাকার দাবিতে আমার দোকানে রেড মারে, সরি ফর দ্য ল্যাঙ্গুয়েজ, সমস্ত রেশন দ্রব্য বাজেয়াপ্ত করে। আমি স্থানীয় মেম্বার ও গ্রামবাসীদের উপস্থিতিতে সমস্ত রেশন দ্রব্যের আধিকারিককে বুঝিয়ে দিই এবং তারা সন্তুষ্ট হইয়া সমস্ত মাল বুঝিয়ে পাইয়ে রিসিভ দেন এবং গ্রামবাসীদের সমস্ত রেশন বুঝিয়ে দেন। আপনার বিরুদ্ধে রেশন গ্রাহকদের অভিযোগ যে আপনি রেশন প্রাপ্ত হচ্ছে কম পরিমাণ দেয়, আমার গ্রাহকদের কন্ট্রোলার সাহেব ভুল বুঝিয়ে অভিযোগটি দায়ের করান। আমার বর্তমানে কন্ট্রোলারের কাছে such and such. Next, he said that the allegations are untrue.
All are long hearings.
All questions. Now, the relevant is 18, my lord, again. These are the usual questions made on the basis of the allegations in the show cause. Then, my lord, 18. আপনি আপনার বিরুদ্ধে যে ষড়যন্ত্রের অভিযোগ করলেন তার ভিত্তি কি? উত্তর, আমার পরিচিত শ্রী বিশ্বজিৎ সাহা এবং ঝিকরা গ্রাম পঞ্চায়েতের সদস্য স্বামী আজাদ সামথিং এর সামনে কন্ট্রোলার এবং গুরুপদ সরকার জনগণের উদ্দেশ্যে কি না সরকার উদ্দেশ্যে বলেন 17 নম্বর প্রশ্নে আপনার বক্তব্যের সমর্থনে আপনার কাছে রেশন না আমি কোনো প্রমাণ তাদের মুখের কথাই বিশ্বাস করেছি এবং সেই অনুযায়ী আমি সেখানে উপস্থিত হই। Then my lord, next page 48. Question number 21. আপনার অভিযোগ অনুযায়ী আপনি মহামান্য সাহেবকে 25,000 টাকা দিয়েছেন, সেই টাকা আপনি কি চেকে না ক্যাশে দিয়েছেন? ক্যাশে দিয়েছি। দেন প্রশ্ন, ঘুষ দেওয়া এবং দেওয়া দুটোই অপরাধ, এটা আপনার জানা আছে কি? উত্তর, জানা আছে, কিন্তু লাইসেন্স বাতিলের ভয়ে দিয়েছি। আইন অনুযায়ী কত টাকা ক্যাশে লেনদেন করা যায় সেটা আপনার জানা আছে কি? না, জানা নেই। দেন 24, যে টাকা আপনি দিয়েছেন সেটার উৎস কি? ব্যাংক থেকে তুলেছিলেন, ঘরে মজুর টাকা থেকে দিয়েছেন, নাকি অন্য কোনোভাবে অর্জন করেছেন? আমি স্ত্রীর গহনা বন্ধক দিয়ে এই টাকা দিয়েছি। দেন যিনি আপনাকে গহনা বন্ধক রেখে 25,000 টাকা দিয়েছেন তিনি কি পড়তে পারছেন না? বিভিন্ন সময় দিয়েছেন নাকি এককালীন দিয়েছেন না গহনা বন্ধক দিয়েছেন? তার নাম কি? নিতাই কর্মকার। গহনা বন্ধকের বিনিময়ে অর্থ সংগ্রহের কোনো নথি আছে কি? রসিদ আছে। হুমকি ও যে অভিযোগ আপনি করেছেন তার বিরুদ্ধে আপনি ঊর্ধ্বতন কমিশনের কাছে লিখিত অভিযোগ করেছেন, সেটা কি 24/8, 29/8 মধ্যে, ওই সময়ের আগে? হ্যাঁ, 24/8 তারিখের আগেই থেকেই আমি এই অভিযোগগুলো জানিয়ে এসেছি। Then, my last regarding shortage, I said the same. The distributor had supplied me less, and that was already intimated. These are the replies. The question is, my lord, when the serious allegations of bribery and my lord, biasness has been made, now the same authority issued the show cause notice, hearing was given, then same authority, my lord, takes steps for termination. My lord, page 51. Now, did he actually consider any of my replies, any of the answers of the hearing? No, my lord, in my humble submission, page 51. Up to, my lord, first page, only reiteration of show cause notice and hearing. the next page, 52. Kindly see the nature of considering my replies by the subdivision controller, how much he was already decided to terminate, proceeded with closed mind from the very beginning. Now, in terms of para 18, the FPS dealer confessed about the irregularity towards close of FPC showing his emergency medical treatment at Salar Hospital. As the shop was closed due to medical emergency, he said, no, that is the confession of your guilt. Whereas the FPC neither informed of the closure of the shop to the office of the undersigned nor any competent authority or Department of Food and Supply. No requirement. Because the time was there, my lord, I need to distribute it. In terms of para 19, FPS confessed about the shortage of stock of pediatrics and also alleged that the same shortage of delivery by Nimai Chandra Das MR distributor. The allegations reply, he didn't make any inquiry whether at all the Nimai Das has gave the distributed lesser quantity of materials or not. He said admitted. First, it is clear that they had received PDS commodities as per government allocated for the month of September. I had specifically said no allotment was given for the September 2023. But he went by the MR distributor showing, and a quantity of rice and a quantity of atta and such sugar has been found shortage. Totally proceeded on the basis of the supply shown to have been made for September. When my specific reply is no supply was made for September. So will again go back to my reply. I have specifically stated no supply was made for September. In terms of para 19(8) of W, denied the matter of distribution of less quantity of food grains to the beneficiary. Whereas during infection, the villagers submitted written objection. Now kindly mark this. The villagers had submitted written objections against the FPS dealer regarding the distribution of the food grains to the beneficiaries. Now, where is this written submission? Has it been at all? Because I had an liberty to question those villagers who had made these written submissions, to cross-examine them. That is the principles. I'll show the judgments also in this regard. That is the principle of law. That when you collect something from third party, you must provide the copy thereof, so that I can have the opportunity to ask them, to call them, to cross-examine them. This was not done. On the other hand, my lord, it was also not disclosed in the show cause notice that any written submission was made. But the submission contract relied on the same. I don't know on what circumstances. Then, my lord, 4. In terms of para 1919, APJ denied the matter of non-cooperation creating of obstruction at the government inquiry. Whereas it has already been observed that during inspection, then Singharai, during personal hearing, FPS dealer stated that due to his emergency medical treatment, the key was not available. Same thing. Then paragraph 5. In terms of paragraph 1911 of control order, FPS dealer confessed about the non-transactions of 25th August 2000 and pending distribution of 198 families. How I have confessed. Whereas APH dealers food served ration promptly without any undue delay, causing inconvenience to the ration card holders. Where the beneficiaries of the service area of the Sunmule had complained before the inspecting team regarding delay and less quantity of distribution. This is absolutely, my lord, these materials would not have been, my lord, relied on in the show cause when it was not supplied. In terms of 1912, FP confessed about the irregularities towards production of stock register and sale register. Then 1906, then conclusion termination. how he had considered my replies, what reasons he had given, that what prompted him to discard my reply to a particular allegation. Page 54, appeal was preferred before the district controller. I'm taking all the points. Hearing was given on 6th December, then the order. Again, question answer, the same reply. Hearing starts from page 69. I will not be traveling, Your Lordship, because the appellate authority, he should have proceeded on the basis of the materials available before him. In any event, he made this hearing, my lord, in a question answer form. Then order is 77.
Yes,
Has Your Lordship got it?
yes.
And last paragraph, these are the reiteration of what happened. On the basis of the so-called notice, Samuel Islam replied on 31st, denied all illegalities. On the basis of reply of the SCFS, Kandi had also issued hearing notice, such and such. There were two replies. There were two so-called notice, which was relied on by the subdivisional controller passing the impugned order, but the DCFS has considered only one so-called notice and one reply. Hearing notice. Then next page 78. The first appellate authority, also fact-finding authority, has jurisdiction to reappraise everything. But what he did later on, after maintaining due procedure in exercise power conferred upon such and such, as mentioned, the termination order during the hearing at the chamber of the applicant denied all charges but could not provide documentary evidence in support of his claim. I have gone through the appeal petitions, grounds of appeal. As per records provided, Kandi seems to have no merit in this appeal, considering the documents, facts, such and such. Approved. No reasons, nothing. Then, my lord, the second appeal at page 79. This appears to be somehow lengthy, but when an attack has been made to the office of the Food and Supply Department, when top to bottom, my lord, everybody knows how they function. Page 88, the impugned order, my lord, is dated 19th March, but communicated on 28th March. That is why.
Yes.
28th March communicated. That is why the impugned order, my lord, in the prayer is 28th March, but it was signed on 19th March 2024. Now, first page, the same thing. Reiteration. Page 89, bottom, learned advocate Aslam Parvez, appearing on behalf of the appellant, has submitted as follows. The appellant went to salary officer due to medical emergency. Therefore, he was compelled to close down his shop on that date, but he performed rehabilitation program on previous day, on 24th August. That the alleged offence of the appellant for which FIR was lodged is sub judice, and the Honorable High Court Calcutta by the interim order to restrain the police authority from arresting the appellant. Then next page 90. that since the appellant license was suspended on and from such and such, no delivery of food grains was made by the distributor doorstep of the appellant shop in the month of September. The question of shortage of stock does not arise. Again, it was reiterated there is no delivery for the month of September. The DCFS may affirm the capital punishment. The appellant did not submit any documentary evidence in support of the claim. According to submission of the SCFS Kandi during the hearing, the appellant appeared with a group of people in front of FPS of BC Singh and others. Then again, criminal proceeding, court of law, department proceeding are separate issues. On 25th of August, the appellant neither opened his shop nor undertaking duration program for duration was pending. The portal in the absence of it. One of the major charges brought against the appellant is shortage of food grains, such and such. The quality of food grains, quantity of food grains was delivered to the appellant in government, such and such. The appellant neither distributed the said allotment quota nor returned the same to the distributor with the again allotment for the month of September 2023. Next page, 91. The second appellate authority went on one step further. There was two so-called notices. The DCFS considered one so-called notice. The second appellate authorities considered the second so-called notice, which was related to the stock of stock. Now, he affirmed the order. ওদের এফিডেভিটটা কোথায় রিপ্লাইটা এই তো রিপোর্টটা আমার কপিটা কোথায় these are all the orders. Now what they had stated in their report, that is relevant, my lord. It also shows that how biased was the subdivisional controller, my lord, against me. The biasness is, my lord, apparent. My lord, it was affirmed by one Sayon Bishas, the same subdivisional controller, my lord, against whom the allegations have been made. Much prior to, my lord, the inquiry. Has you also got it, my lord? Now kindly take page 3. Paragraph 6. Subparagraph C, that in connection with the diligent performance that claimed by the petitioner is completely false and fabricated, he misleads the court. It is specifically mentioned here in that as per available office record, petitioner is habitual offender. On 6 June 2021, the BDO of Bharatpur had visited at the FPS permit and found some anomalies. Well, the BDO was not the competent authority, but in any event, anomalies and discrepancies for which a show-cause notice was issued on 10 July. Secondly, on 17th March, a large number of people of Jhika village sent mass petitions before the authority concerned about the irregularity of the petitioner. These are not part of the show-cause. Nothing. A surprise visit had been conducted in front of the petitioner and found illegality and suspended the petitioner for his illegal action for the reasons had repeatedly. Then, my lord, D, page 4.
Yes.
On 2nd May 2023, being an habitual offender, the petitioner had come to the office of the undersigned on different occasions and used to deliver foul language to the office staff and stakeholders, whoever present at the moment, and heckled them in various manners. These types of untoward incidents have repeatedly happened on different occasions. and a general diary had been lodged in Kandi police station and Murshidabad police station against the petitioner white letter numbers in connection with the Hakel misbehavior. Well, these happened when this regular monthly payment was being asked for. And the same persons now proceeded to issue show cause and hear. Well, nobody can be judge of his own cause. Well, that is because it is his personal grievance against the petitioner. Now, it is pertinent to mention here that on 24th August, about 3 p.m. and in about 3 p.m. Kindly mark that time. I'll show from the control order. About 3 p.m. an inspection team of the department at the point of time Shamil Islam allies such and such had created obstructions in the government. That is the Vishnu. On 24th, for creating obstructions, FIR had been lodged. That is the where I got the anticipatory bill. Then paragraph G. But
these are the so-called points
no,
like that.
One fact, page 5, kindly take allegation 7. The same thing also, you will find from the appellate authority's order. It also reveals from the inspection report that at the time of inspection of the village Sundarpur, the beneficiaries complained that the petitioner does not provide entitled quantities of food grain and beneficiary as per approved scale. The petitioner also misbehaved with them. Kindly come back to the show cause notice, page 31.
Point number 8.
8. H. It is also mentioned herein that after receiving the inquiry report, not supplied inquiry report. And there was an inquiry report which was forwarded to the SCFS, but it was not supplied. Now then reiterated show cause supply. Then page 8. Now, in order to castigate me, that how bad I am, the subjudicial goes beyond what happened, the suspension, termination. On 20th July 2024, it was found that 19th March is the order of the second appellate authority. Now, he refers to these subsequent facts, only to prejudice, not only the court, also makes further allegations. It also reflects his reflects his personal grievance against me. But he refers to that how I have agitated. Then P. This is after that 17 December 2024. P. That you also will not find two things. One is that non-supply of inquiry report and non-supply of complaint. It was admitted that they did not supply. But page 13, paragraph 10, II, there was a written complaint, allegedly a legit written complaint of the villagers that was not supplied to me. That has been referred to. Now, another important thing, page 14, subparagraph Roman 4. Kindly see the annexure. Has the lordship got it? Copy of the report of the public opinion is annexed here too. I am putting a question to myself. What for? Only to prejudice the court. Let's see that how bad I am. Then, my lord. So these are the allegations, my lord. I have nothing to show from here. So my points are, my lord, this is those gross violation of principle of natural justice. From the very beginning, the subdivisional controller was biased and acted with closed mind because of, my lord, the complaints made by the petitioners repeatedly against him. And even if, my lord, for the sake of argument, if I presume that there was a valid inquiry, valid allegations, it was absolutely, my lord, necessary for the subdivisional controller to not to hear this, my lord, inquiry, not to conduct the inquiry by himself. He should have been, my lord, chosen another, my lord, officer.
Yes.
But a fast judgment I'll be showing in respect of, my lord, biasness. It's 1993 4 SCC page 10.
It's about
10. এক সেকেন্ড এই তো এই যে এখানে কপি বের করো paragraphs 10, 11 and 12. Paragraph 10. Since the rules of natural justice were not embodied rules, it is not possible and practicable to precisely define the parameters of natural justice. In Russell versus Duke of Norfolk, Tucker Lord J observed that there are, in my view, no words which are of universal applications to every kind of inquiry and every kind of domestic tribunal. The requirements of natural justice must depending on the circumstances of the case, nature of the inquiry, and rules under which tribunal is acting, the subject matter that is being dealt with, and so forth. It has been observed by this court in Union of India versus Piqueroy. The extent and application of the doctrine of natural justice cannot be imprisoned with a straitjacket or rigid formula. The application of the doctrine depends upon the nature of jurisdiction conferred on the administrative authority, upon the character of the rights of the person affected, the scheme and policy of the statute, and other relevant circumstances disclosed in the particular case. Similarly, the view was also expressed in such and such. I am skipping it. These are the well-settled principles. The last part, one of the cardinal principles of natural justice is nemo det esse judex in propria cause. No man shall be judge of his own cause. Has the last got it? Last part.
Yes.
It has been held by this court in secretary to the government of transport department that a predispositions to decide for or against one party without proper regard to the true merits of the dispute is bias. Personal bias is one of three major limbs of bias, namely pecuniary bias, personal bias, and official bias. A classic case of personal bias was revealed in the decisions of this court in state of UP versus Mohammadou. In the said case, a departmental inquiry was held against an employee. One of the witnesses against the employee turned hostile. The officer holding the inquiry then left the inquiry, gave evidence against the employee, and thereafter resumed to complete inquiry and pass the order of dismissal. This court quashed the order of dismissal by holding inter alia that the rules of natural justice were grievously violated. Then, my lord, 11. In the instant case, charge number 12 states that a particular sum on account of amalgamated fund for the month of December was given to the appellant by Sri Maruram, who was teacher in charge of the amalgamated fund. In the inquiry committee comprising of 3 members, the said Maruram was taken as one of the members and he himself deposed to establish the said charge number 12. And thereafter again joined the inquiry committee and submitted a report holding the appellant guilty of some of the charges, including the said charge number 12. Sri Maruram was interested in establishing the said charge. From the charge itself, it is apparent that he had predisposition to decide against the appellant. But why I am saying so, you also will find from the first show cause notice and the reply submitted before this, that you also will find the same pattern. Since I had made allegations, serious allegations repeatedly, the subdivisional controller has a grudge against me. And he was determined to proceed against me and to terminate my dealerships. And that is reflected from the statements, from the allegations in the show cause, and subsequently relying upon the report and the complaint, which non-supply of report and complaint and ultimately the findings. Actually, he didn't dare deal with my reply. He straight away come because he was already decided, this matter was already decided. So this also reflects from his report. Then, my lord, may I continue?
Yes.
After they said Maruram was interested, from the charge itself, it is apparent that he had predisposition to decide against the appellant. It is really unfortunate that although appellant raised an objection before the inquiry committee by clearly indicating that Sri Maruram was inimical towards him and he should not be a member of the inquiry committee, such objection was rejected on a very flimsy ground, namely that since the Sri Maruram was one of the members of the managing committee and was the representative of the teachers in the managing committee, it was necessary to include him in the inquiry committee. He had no such. In fact, the judge was against whom I made the complaint. He proceeded to conduct the hearing and pass the order. It's more serious than here. It is quite apparent that the inquiry committee could have been constituted with other members of the managing committee. And the rules of the inquiry are not such that the Sri Maruram, being teacher's representative, was required to be included in the said inquiry. So the doctrine of necessity may be attracted. If the person has a pecuniary interest, such interest, even if very small, for appreciating a case of personal bias or bias to the subject matter, the test is whether there was a real likelihood of bias, even though such bias has not in fact taken place. Now, D. Smith, in his judicial review of administrative actions, has observed that a real likelihood of bias means at least substantial possibility of bias. It has been held that the court will have to judge the matter as a reasonable man would judge of any matter in the conduct of his own business. In R versus Sussex Justices, it has been indicated that the answer to the question whether there was a real likelihood of bias depends not upon what actually was done, but upon what might appear to be done. In Halsbury's Laws of England, 4th edition, volume 2, para such and such, it has been indicated that the test of bias is whether a reasonable, intelligent man, fully apprised of all the circumstances, would feel a serious apprehension bias. If I am a reasonable man, I apprehended that there is a biasness. The same principle has also been accepted by this court in Manaklal versus Dr. Premchand. This court has laid down that the test is not whether in fact, a bias has affected the judgment, the test always is and must be whether a litigant could reasonably apprehend that a bias attributable to a member of the tribunal might have operated against him in the final decision of the tribunal. It is in this sense that it is often said that the justice must not only be done, but must also appear to be done. Then 12. Then then in paragraph 12, Supreme Court, my lord, again, my lord, process what the facts in the present case and what High Court did ultimately found. But may I just read the paragraph 12 last portion, the observation of Eshad Das, my lord, paragraph 12, next page, last line, the observation of Eshad Das C in কত হচ্ছে 26 হচ্ছে চলে যাও Eshad Das CJ in Muhammad versus No, where the error, may I just next page, where the error, irregularity or illegality touching jurisdiction or procedure committed by an inferior court or tribunal of the first instance is so patent and loudly obscure that it leaves on its decision an indelible stamp of infirmity or vice which cannot be obliterated or cured on appeal or revision. In any, if an inferior court or tribunal of the first instance acts solely without jurisdiction or patently in excess or manifestly conducts the proceedings before it in a manner which is contrary to the rules of natural justice and all accepted rules or procedure which offends the superior court's sense of fair play, the superior court may, we think, quite properly exercise the power to issue the prerogative writ of statutory to correct such error. This is the first instance the wrong was committed. The whatever illegality has been committed by the subdivisional controller, the appellate, both the appellate authority has affirmed this based on what the findings recorded by the subdivisional controller and the what he reported before such first and second appellate authority. The mere affirmation or stamping affirmations by the first and second appellate authority will not cure the decisions of the subdivisional controller. If it is erroneous, illegal, it will remain illegal and erroneous. And if the first decision goes, automatically the first appeal and the decisions on first appeal and second appeal will also go. Now, next judgment, my lord, I'll show. This is my favorite judgment. The unreported one. The how the this in a show cause proceeding, particularly in relations dealers matters. The how to what is the obligations to comply with the natural justice. My lord, this is I'm giving a copy to my learned friend. This is by the Honorable Justice Jayanta Kumar Vishwas, as the Lordship then was, delivered in WP number 1711 W of 2006, judgment dated 28th of July 2009. It was upheld, may I just take the next page, last paragraph? In the impugned order, the subdivision controller has recorded that the petitioner appearing before him on June 6, 2006 refused to participate in the hearing, that in the written representation submitted, he alleged that the copy of the documents had not been supplied to him. But since he never demanded a copy of any document, there was no question of supplying copy of any document to him. That since the notice of show cause was issued and he was given opportunity of personal hearing, there was no scope for contending that the principle of natural justice were not followed. That the reports of the inspecting team do not corroborate the case of the petitioner. That the petitioner failed to produce registered carbon copy of case memos in support of his contention, though he was asked to produce the documents at the time of hearing. Now, it is evident from the facts noted here in above that the copies of the complaint and the inquiry report were not supplied to the petitioner on the ground that he did not demand copy of the documents. My lord, I am pausing here for a moment. In the present case, I demanded that no one proved the complaint and the complaint and the inquiry report by adducing any evidence before the sub-divisional controller. That the authors of the complaint, my lord, here the villagers have made the written complaint. The authors of the complaint and the inquiry report were not examined or made available to the petitioner's cross-examination. That the sub-divisional controller did not give the petitioner an opportunity to adduce evidence in his defense, and the sub-divisional controller gave the petitioner only an opportunity of hearing. Now, at the date of proceedings were initiated, the West Bengal 2003 control order was in force. According to the provisions of the order, all MR dealers were to be treated as fair price shop owners. It is submitted that the necessary government order was issued for issuing the requisite license to the existing MR dealers for carrying on. In the case, the petitioner, the license could not be issued presumably because the proceedings in which the impugned order was made were pending at the relevant date, but the parties proceeded on the basis that the pending proceedings would be governed by that provisional 2003 order. By the impugned order, the sub-divisional controller has cancelled the petitioner's license to carry on business as a fair price shop owner. The petitioner did not appeal from the impugned order principally for two reasons. In the present case, I appealed. It was passed in gross violation of principle of natural justice. Although there was statutory requirement of getting approval from the higher authority, the sub-divisional controller sought approval for his decision from the higher authority. In ordinary case, the petitioner would have been entitled to appeal from the impugned order to the district controller concerned. In the present case, the sub-divisional controller sought and got approved for his decision from the Director, District Distribution Procurement Supply, the superior officer of the district controller. Now, this was the challenge, that I am unable to accept the case that since the petitioner did not demand copies of the complaint and the inquiry report relied on by the sub-divisional controller, the sub-divisional controllers were under no obligations to supply him copies thereof. In my opinion, once the sub-divisional controller decided to rely on the complaint and the inquiry report, both of which were admittedly prepared behind the back, petitioner's back, the sub-divisional controller incurred the obligations to supply the petitioner copies thereof, giving him reasonable opportunity to deal with the contents thereof. By not supplying copies of these materials, the sub-divisional controller denied the petitioner a reasonable opportunity to defend himself. Allegations made against the petitioner were not proved by anyone by adducing evidence before the sub-divisional controller, who treated things stated in the complaint and the inquiry report as sacrosanct. I am pausing it. Here, the sub-divisional controller relied on a purported complaint of the villagers of Sandargarh, something like that, and no villagers came to depose before him. The complaint was never supplied to the petitioner. The sub-divisional controller could not treat the allegations made in therein as true. The authors of the complaint and the inquiry report were not made available to the petitioner for cross-examination. This also amounted to denial of reasonable opportunity to the petitioner to defend himself. By not giving the petitioner reasonable opportunity to adduce evidence, by inviting him to do so, once again the sub-divisional controller denied him reasonable opportunity to defend himself. The sub-divisional controller could not proceed on the basis that the petitioner was asked to participate in the hearing, and at the time of hearing, he failed to produce documents in support of this case. Then said, in my opinion, sub-divisional controller followed a totally unfair procedure. It is not known under what authority he wanted director's approval. This is not the point I have in the present case. So how this smaller natural justice to be complied with in this type of quasi-criminal proceedings, that has been dealt with in the present case. Now, next judgment, I will be relying on 2010-13 SCC 427, which is Oryx Fisheries. I had this judgment I had relied on before your lordship on earlier occasions also.
এটা পেজ
প্রফিটিং
ঠিক আছে ঠিক আছে হ্যাঁ স্যার
paragraphs 23, 24, 23 to 28, then 32 to 36 and 41. Here also the court considered the issue of biasness. 23 may just before I goes to judgment, kindly you will also kindly come back to page 31 once again. Page 31 of the writ petition. Just from allegations 5, kindly come back to page 31 once. Allegation 5, the dealer has distributed less quantity of food grains to the beneficiary. This is not based on anything. It is the allegation sub-divisional controller has shown. He didn't say that it has been alleged that distributor, because he had formed his opinion at that time of issuing the show cause. Then his behavior was reactionary, was very bad. Previously, the said dealer was suspended by such and such for gross violation. During the inspection at Sundarpur village, government complained of the dealer does not provide entitled beneficiary, approved the scale of trade, misbehaved with them. So he said this is the conclusion. Then this is gross violation of the order. These acts are gross violation of the order, hence he was so cause. Why punishment will not be imposed. So keeping in mind with this smaller so cause, now kindly take paragraph 23. Relying on the underlying portions in the show cause notice, the learned counsel of the appellant asks that even at the stage of show cause notice, the third respondent has completely made up his mind and reached a definite conclusion about the alleged guilt of the appellant. This has rendered the subsequent proceedings an empty ritual and an idle formality. This court finds well settled that a quasi-judicial authority, while acting in exercise of the statutory power, must act fairly and must act with an open mind while initiating a show cause proceeding. A show cause proceeding is meant to give the person proceeded against a reasonable opportunity of making his objections against the proposed charges indicated in the notice. Expressions like a reasonable opportunity of making objections or reasonable opportunity of defense have come up for consideration before this court in the context of several statutes. The Constitution bench of this court in Khemchand versus Union of India, of course, in the context of service jurisprudence, reiterated certain principles which are applicable in the present case. Then Esha Das CJ, speaking for the unanimous Constitution bench in Khemchand, held that the concept of reasonability includes various safeguards, and one of them, in the words of the learned Chief Justice, is an opportunity to deny his guilt and establish his innocent, which he can only do if he is told what the charges leveled against him and the allegations on which such charges are based. It is no doubt true that at the stage of show cause, the person proceeded against must be told the charges against him so that he can take his defense and prove his innocence. It is obvious that at the stage of the authority issuing the charge sheet cannot, instead of telling him the charges, confront him with definite conclusions of his guilt. If that is done, as has been done in the instant case, the entire proceedings initiated by the show cause notice gets vitiated by unfairness and bias, and subsequent proceedings become idle ceremony. And justice is rooted in the confidence, and justice is the goal of quasi-judicial proceeding also. If the functioning of a quasi-judicial authority has to inspire confidence in the minds of those subjected to its jurisdiction, such authority must act with utmost fairness. Its fairness is obviously to be manifested by the language in which charges are couched and conveyed to the person concerned. In the instant case, from the underlying portion of the show cause notice, it is clear that the third respondent has demonstrated a totally closed mind at the stage of show cause notice itself. Such closed mind is inconsistent with the scheme of Rule 43, which I have set out below. I am skipping it, then 32. Therefore, while issuing the show cause notice, the authorities must take care of manifestly keep an open mind, as they are to act fairly in adjudicating, in adjudging the guilt or otherwise of the person proceeded against, and especially when he has the power to take punitive step against the persons after giving him show cause notice. The principle that justice must not only be done, but it must eminently appear to be done, as well is equally applicable to quasi-judicial proceeding. If such a proceeding has to inspire confidence in the mind of those who are subjected to it. And I'm just skipping. Paragraph 35, going by the aforesaid test, any man of ordinary prudence would come to the conclusion that in the instant case, the alleged guilt of the appellant has been prejudged at the stage of show cause notice itself. The appellant gave reply to the show cause notice, 36, my lord. Appellant gave reply to the show cause notice, but in order of the third respondent by which registration certificate of the appellant was cancelled, no reference was made to the reply of the appellant, except saying that it is not satisfactory. The cancellation order is totally non-speaking of the relevant portion of the cancellation. Then this has been quoted. Then kindly take, my lord, 41 straight away. The 40, my lord. Here also, my lord, why I am showing 41? Because here we will also find that district controller order virtually contain no reason. But the second appellate authority tried to give some reasons. Well, he considered the submissions made on behalf of the learned advocate on appearing for the petitioners, and that is why, my lord, paragraph 41. Kindly take, my lord. The instance case, the appellate order contains reasons. However, absence of the reasons in the original order cannot be compensated by disclosure of the reasons in the appellate order. Now, what was, my lord, in last line of the show cause notice, that I am just pointing out the facts. Now, kindly take paragraph 22. Paragraph 22, the next, next paragraph 22 of this judgment. The page over, my lord, one. Next page. Last line was subparagraph 3. These irresponsible actions have brought irreparable damage to the India's trade relations with the UAE. Hence, you are requested to show cause. This was the allegations was taken exception of. The last judgment, 2023 6 SCC, page 1. But most probably I may be wrong, my lord. 22 is the show cause. Your attention is invited. It was 23. Your reply should reach the undersigned, failing which it will be presumed that you have no explanation. Yes. 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 হয়ে গেছে কি বললো I'm sorry, my lord, I couldn't find it, my lord. That is 23. Relying on the underlying portion. Yes. Yes. See? It has been proved beyond doubt that you have sent substance maintenance.
Concern has issued show cause with such observation.
That is why
it is beyond doubt to the authority.
Yes, but I had shown also their allegation that your behavior is bad. It's a conclusion. Kindly take page 31 once. Is conclusion. Up to five from 5 to
6. His behavior.
5, 6, 7, 8. Conclusive finding is what because nothing to do with matter why he is so two things. One is predispositions of the subdivisional controller. That is why he referred the earlier alleged violations of 23rd February 2023. Because there was no charge against it. Then allegations. Now, what can I reply? That yes, I said that it was a concluded proceedings. You cannot. But why he referred it? Because these discloses his mind also. It's up to to consider, Malad. Malad, next judgment, Malad, is 2023 6 SCC, page 1. A copy.
No.
Rather lengthy judgment, Malad. Natural justice also. Paragraphs are 36, 46, 80, 81, 84, 80 to 87. Since I had relied on a single judge decision, Malad, of this court, Malad, paragraph 36, Malad, kindly take. As you also got it. E2. আমি তো টাইমই করতে তাই পরিবে একটা সামান্য প্রোটেকশন দেবে না এর জন্য ইয়েস মাদার ভার্চুয়াল রিসার্চ অফিস এরা বলতে আমাকে কিছু করার নেই। Alright, we need to bear in mind that the principles of natural justice are not mere legal formalities. They constitute substantive obligations that need to be followed by decision-making and adjudicating authorities. The principle of natural justice act as a guarantee against arbitrary actions, both in terms of procedure and substance, by judicial, quasi-judicial, and administrative authorities. Two fundamental principles of natural justice are entrenched in Indian jurisprudence. One is nemo judex in causua sua, which means that no person should be a judge in their own cause. Why I am because 93, the same principles now reiterated in 2023. And audio alteram partem, which means that a persons affected by administrative or judicial or quasi-judicial action must be heard before a decision is taken. The courts generally favor interpretations of a statutory provisions consistent with the principle of natural justice because it is presumed that the statutory authority do not intend to contravene fundamental rights. Application of the said principles depends on the facts and circumstances of the case, express language and basic scheme of statute under which the administrative power is exercised, the nature and purpose for which the power is conferred, and the final effect of the exercise of that power. Then 46, my lord, some judgments have been considered. There is a, as you also got it, there is a consistent pattern of judicial thought that the civil consequence entail infractions not merely of property or personal rights, but also civil liberties, material deprivations, and non-pecuniary damages. Every order or proceedings which involve civil consequences or adversely affected citizens should be in accordance with the principle of natural justice. Then you will also kindly straightway come to paragraph 80. As well. Audio alteram partem has several facets, including the service of a notice to any persons against whom a prejudicial order may be passed and providing an opportunity to explain the evidence collected. Kindly mark this, evidence collected. Why I am pointing out, has also got it, third line. Because they said at the inquiry that the complaint has been, written complaint has been collected. The inquiry report has been collected. In Tulsiram, applicability of the audio alternative patent. The rule of natural justice with which we are concerned in these appeals and writ petitions, namely the audio alternative patent rule, in its fullest amplitude, means that a person against whom an order to his prejudice may be passed should be informed of the allegations and the charges against him, be given an opportunity of submitting his explanation thereto, have the right to know the evidence, both oral or documentary, by which the matter is proposed to be decided against him, and to inspect the documents which are relied upon for the purpose of being used against him, to have the witnesses. In 2009, the learned single judge exactly had spoken on the same line. By which manner he proposed to be decided against him, to inspect the documents which are relied upon for the purpose of being used against him, to have the witnesses who are given, who are to give evidence against him, examine in his presence and have the right to cross-examine them, and to lead his own evidence, both oral and documentary, in his defense. The process of a fair hearing need not, however, conform to the judicial process in a court of law, because judicial adjudication of causes involves a number of technical rules of procedure and evidence which are unnecessary and not required for the purpose of a fair hearing within the meaning of audio alter important rule in quasi judicial. Then, my lord, next paragraph is 81. Audio alter important therefore entails that an entity against whom evidence is collected be provided an opportunity to explain the evidence against it, be informed of the proposed action, and be allowed to represent why the proposed action should not be taken. Hence, the mere participation of the borrower during the course of preparation of a forensic audit report would not fulfill the requirements of natural justice. Why I am stressing on these 3 lines? Because inquiry was taken in behind my back, but even if I was present, even then that didn't absolve the authority from supplying the copy of the report. Didn't absolve the authority from supplying the written complaint received from some villagers. The decision to classify an account as fraud involves use the tender bank. I have not decided whether the borrower has breached. Therefore, the principle of natural demand that the borrower must be served a notice, given an opportunity to explain findings in the forensic audit report, and to represent before the account is classified as fraud under the master directions on fraud. Then paragraph 84. In EP Royappa versus State of Tamil Nadu, this court held that an arbitrary state action is violative of Article 14 of the Constitution. Again, in Maneka Gandhi, this court reiterated that the principle of non-arbitrariness pervades Article 14, and administrative actions can be tested for constitutional infirmities under Article 14 on 4 grounds: unreasonable or irrationality, illegality, procedural impropriety, and proportionality. However, the scope of judicial review is limited to ascertaining the deficiency in the decision-making process and not the correctness of the choice made by the administrator. 85. The fairness in actions requires that the procedure which permits impairment of fundamental rights ought to be just, fair, and reasonable. The principle of natural justice have a universal application and constitute an important fact of procedural propriety envisaged under Article 14. The rule of audio alternative is recognized as being a part of the guarantee contained in Article 14.
Other matters to be released, now.
I'll not say, I'll just say this is the last judgment. Will not leave Dolaputi. Huh? Yes, the principle then thus come to be recognized by the same thing. Then, my lord, 86 and 87. My lord, 87 I will be reading because 86. Administrative proceedings which can because why I am showing the principle of natural justice is embedded in the Article 14. If it is violated, it will constitute violation of Article 14. That the Supreme Court also held. So, these are my submissions. সব দেখানো হয়ে গেছে।
May I comment, my lord? Please keep it on the next day, my lord. Grateful one. Grateful one.
Respondent state Because another applicant will come on that day. I am sure, my lord. One after another. My lord, I trust, my lord, that because I can rely on a judgment of the Honorable Supreme Court delivered recently, that when a writ is sub judice before the High Court, that the authorities cannot take any actions which will make it infructuous. That is the latest judgment of the Honorable Supreme Court. I can cite if they want, my lord. Let it be.
No, I will convey that the matter is pending, lordship, will not take any coercive steps, my lord.
Unless recorded, my lord, if there is a change, then I will be in spook, my lord.
Grateful, my lord.
Grateful, my lord.
My lord, I'm praying for an accommodation. I'm for the private respondents.
Your Lordship, I appear for IUCL, Your Lordship.
I'm for the petition, Your Lordship. Lordship, kindly pass over. I am led by Mr. Shomabha Mukherjee. Lordship, kindly keep it a day after tomorrow or
Grateful, man. I am for the petitioner, my lord. I have concluded my submission. Now, this is a matter, my lord, where the suspension order has been issued. Yes. Yes. They have started also, my lord. Suspension along with fine. So far the fine part is concerned, that has been stayed by the coordinate bench, but so far the suspension is concerned, that is continuing. But there, your lordship knows, there is a judgment of the division bench that suspension cannot be continued after 60 days. Proceedings may continue. That period has also been expired. Today I covered by the division bench judgment, which says, my lord, you have to conclude the proceedings either or suspension shall be revoked. Muhammad Yasin, 1996, volume 2, CHN, page 411. Proceedings may continue, but suspension must go. Because my bread and butter has been withheld. Long back order of suspension has been issued. And if they paid for time and again, my lord.
Well, kindly fixes another date, my lord. Yes, ma'am.
My lord, in item number 14, my lord, Mohammed Sarojini is appearing on behalf of the petitioner, my lord. My lord, today is fixed for reply, but he was on here, my lord. But now he engaged in code number 2. My lord, he is in page.
My lord, I have been accommodated in the second row of lot, in second lot of LPG. I have been awarded. I am continuing. My learned friend is claiming that he should be appointed there. That's why we have already, Mr. Surjit Mitra, my lord, has already made submission. He is to reply. Let it taken tomorrow, my lord, since he is not here.
Otherwise, not today, not this week, my lord.
No, I am sorry. Okay.
My lord, not this week, my lord. Wednesday, he is not available, my lord.
I have no objection, my lord, because I am continuing with the business. I have no, even if your lordship takes up 26 August.
Grateful, my lord.
deeply.
তরফদারি জাতীয়
Yes. নেই কেন আমার
Bengal agency. Proceeding Mr. Torotdar is appearing. Or my name is Advocate General. Who is for the petitioner, my lord? Mr. Torotdar. So that matter, Mr. Torotdar has already concluded his submission, possibly Advocate General. তোরা কোথায় থাকিস বলে একটা কথা আমার তো লিস্টই নেই লিস্ট কোথায়
এই তো 27 থেকে আমার কাছে সেম
তারপর ওই যে ওইগুলো কোথায়
কোনগুলো
ওই মৃদুল ওই
ওই এই তো পরপর তো শামসুজ্জোয়া ইন্দ্রনীল
আচ্ছা ওই কত দূরে ও মাঝখানে ইয়েটা আছে
হ্যাঁ 27 থেকে
মানিস ভিতর লক্ষ্মী মে adjourn this matter Mr. Torotdar I shall intimate him. Yes. Yes. So your lordship making it not today or any day? I shall tell him.
60. You stated. I am for the private respondent. Petitioner mentioned this matter and fixed the matter before your lordship. Oh, yes, please.
Paying for the petition.
Milord, on the 11th hour, Milord, I had been served the supplementary affidavit, Milord. This is my affidavit in reply.
This is my exception to the report and the supplementary affidavit.
Right.
On the last occasion, your lordship had granted liberty to file a supplementary affidavit. Lordship. And the exception to the state's report.
And I served the copy upon both the parties.
Yes.
Lordship, over here I have challenged one FPS notification, the appointment of the private respondent. Lordship, what in this matter, what had happened was the FPS dealership has been given to the private respondent, but the location for which the FPS was declared, the godown of the private respondent is not located in that particular place. Your Lordship, I rely upon one precedent of your Lordship, the judgment being.
Yes.
Lordship, the location is Araji Mulu. Lordship, but that of the private respondent, it was submitted by the state itself that neither the petitioner nor the private respondent has their own godown at the concerned location for which the FPS was declared. Lordship, my prayer was that if none of the criteria is being fulfilled, then in such case, a fresh declaration should be made and a fresh appointment should be made, Your Lordship. And on the similar footing, Your Lordship had already. Lordship, the same was already submitted by the state council on a previous occasion, Your Lordship.
The exception was exception. এই তো exception to the ওরা দিয়েছে এই তোদের এটা রিপোর্ট
Pathroy Lordship, the notification being at page 15. Over here, the location was specified as Araji Muluk near Thakurbari. But your lordship, the private respondent's location is not at Araji Muluk near Thakurbari. Rather, your lordship, it is located at it's her Godown is located at Moja Muluk, and Moja Muluk and Moja Araji Muluk are two different places. And as per clause 12, subclause 4 of part 2 of the notification, it clearly specifies that the Godown has to be within the vacancy location. Lordship, my contention was even my Godown is not within that particular location.
Yes.
Now there is a distance gap.
Yes.
Now the question arises that if none of them fulfill the criteria, then in such case, the state should have called for a fresh application, because it doesn't mean that if none of the applications fulfill the criteria, they can randomly proceed with someone. Lordship,
Yes, my lord. Yes, my lord. And from the very inception.
Lordship, with respect to all the allegations, Lordship, I have already countered that. It was also stated by the Lordship, the state had submitted in the report that we do not have a shade, and the shade is a primary criteria. Lordship, we had stated that whatever area was specified, that I have specified in my application is a carpet area. And number 2, I have also annexed a copy of the picture of the shade. How can the state submit in its report that there is no shade? Because of which, your lordship, I made several RTI applications and I prayed for a fresh inspection. Because the state cannot simply come and state that you do not have a shade in your Godown, where in my supplementary affidavit, I've clearly given a picture which shows a shade. That means the inspection report is faulty. So there must be a fresh.
Yes, my lord, that can be.
That is not a subsequent shade, your lordship. Lordship, if I may rely upon your lordship's judgment in a previous case, that was lordship, but lordship, in the previous writ petition being WPF 5239 of 2023, the same question arose, your lordship, that both of them had not fulfilled, and over there the reason why the private respondent had not fulfilled was the reason that it was not within the location.
Yes.
Lordship, I am raising questions at the inspection report as well, your lordship, because how can they come and say that there was no shade? Because I was not present at the time of the inspection. I was present at the time of the interview, which had taken place in the office of the SENFS. No, your lordship. And that is why in my supplementary affidavit, I specifically shown a picture of the shade. Let the local people say whether the shade was there or not. Let there be a fresh inspection. Lordship, that is what I'm. My allegation is against the very inspection. Lordship, the inspection itself is faulty, and lordship, my primary ground was the location, your lordship. And furthermore, your lordship, the people who are coming to collect it, they are from the very village where my Godown is located. Now, if I may even humbly accept the fact that my Godown also doesn't fulfill the criteria, but then on what basis the private respondent getting? Because both of us, lordship, and my one is about 800 to 900 meter. The difference is about 100 to 200 meters. Now, whatever allegation has been placed with respect to the from the original location. So I have a better case over there. Lordship, with respect to that only, I have questioned the very inspection, your lordship. That is the very basis. Lordship, only one judgment, if I may rely upon, only one judgment. Lordship. That was done after the report was submitted. In my exception, that is what I've pleaded. Lordship, in the report, they have stated all those particular points on the basis of which my application was rejected. Only after going through the report, I have filed my exception. And in that exception, I've taken up all those grounds and I've countered them, your lordship. Lordship, whatever the grounds for my cancellation was stated by the state in the report. And subsequently, I've countered all those points in my exception. And because I wanted to compare it with the private respondent, I made several RTI application, RTI appeal, and I have annexed all of that in the supplementary affidavit. I want to come clean before your lordship with all the documents. because of which I prayed for liberty to come up with a supplementary affidavit. The local people themselves can say whether the shade is an old one or a new one. They cannot just simply say there was no shade and there is a shade existing. What I say, Your Lordship, humbly submit, Your Lordship. Lordship, in my exception, I've clearly counted all their points with respect to shade and the area. Lordship. Because all those exact point was not known to me that on what basis is my application rejected, because of which I have relied upon that report and then made the exception. Because prior to that report, I was not aware of the ground for which I was rejected. Lordship. Lordship, I have stated that with respect to carpet area, I do have to let there be a fresh inspection, Your Lordship. Supplementary, I have made an RTA application. Thereafter, when I didn't get a suitable answer, I made a first appeal and then a second appeal, Your Lordship. That has been annexed in the RTI. Supplementary. Lordship, I had prayed for the inquiry report of the private respondent. That was not supplied to us, Your Lordship. What's stated? Lordship, only the petitioners, not the private respondents. Lordship, private respondent have got, that has been stated, but what was the inquiry report? What was the inspection report? That was not provided to us. Lordship, that is the application, but not the inquiry report. Like, what was the...
জিজ্ঞেস করলো তখন
Kaushik Das. No. In the inquiry report is of Kaushik Das.
Yes.
This is Basudev Patro. So these are the Basudev Patro.
Well, there is an inquiry in regard to this two persons. One is the who has granted this license. There is the private respondent and annexer
Rima Chakravarti.
This is that report is not been supplied me, but my report has been supplied as it appear and annexers in the petitions in the report in form. No, because we have already made this RTI. That RTI has been report that private respondent's report cannot be supplied to you, because this is the private respondent's report. That report cannot be supplied to me. Even that I made an application under the RTI. That RTI, no report is only in respect to the writ petition. After RTI, they have received. After RTI, after filing of the RTI application, that report has been supplied to me. But so far, my report is concerned, that is also in presence of that report was made by the inspection authority. Yes. I have. But that report is corroborated. This is not entirely corroborated regarding this. My fact is concerned. So far, this Godown space and other things according to the 2020, 24, 23, 22 notifications. That notification is to be clarified, because paragraph 5 and 7 I will categorically stated that this report is totally vague, whereas the inspection authority are biased in favor of the private respondent. Number 6. You'll also kindly explain regarding the explanations in regard to this report, as well as the illegally made in respect of the inspection authority by reporting of the report. That on the next date, you'll kindly address, because time is over. So, my lord, so, my lord, no, but no, my lord, only my lord, kindly, my lord, because my lord, one matter has been, my lord, arguing in court number 11. Just now, my lord, I have release of this, my lord, from this court number 11. Because I have, yes, in another day, my lord. I will.
Prior to fixing,
my
Lord,
lord,
may
I
I
have to
get
satisfy your
audience
lordship
for
regarding-
1 minute, my lord?
Only, my lord, only my lord, time to be given, my lord, only 1 day or 2 day, my lord, any day your lordship will convenience.
Private respondent. My lord,
Because he is
Lord, I am running the business.
running the business.
My. After vacation, my lord.
After vacation. My lord, vacation is there after my lord 26th September. No, prior to that only my lord 1 minute. I have already my lord gone out of picture. At 2 p.m.
Before rising,
make it pattern because my lord, so many my lord, determinations my lord, now it changed. If that only make it pattern, my lord, your lordship my lord, decide this matter and dispose of this matter on that day. Your lordship will think about it.
Before rising, maybe permit to mention on urgent matter. Item number 32. What happened, my lord? I have filed an application for appropriate order that the authority cannot issue the license in respect of the private respondents during the proceedings, as the matter is subject before lordship. Now, my lord, when your lordship last week could not my lord sit in the before his lordship personal difficulties. In this time, my lord, what happened? The authority, my lord, issued the include the name of the private respondents in the list of ration, my lord, ration dealers. Yes, but only my lord, name has been mentioned in the website, but till date, my lord, no. So, my lord, kindly no interim order is there, but I have filed an application for appropriate order. So during my lord, as per latest Supreme Court judgment, my lord, that under the heading 2 p.m. kindly give some preference, my lord, so my matter can be heard out by your lordship, and in the minute give some protection. My learned friend is appearing. State ID for the private respondent. Not to give any effect or further effect. Only this, my lord. My lord, this is the my lord, Rohit Sahib list. This is the Rohit Sahib.
There was no interim order, and that is why
That they cannot do that when no. This is regarding to compassionate appointment. Compassionate appointment. So, my lord, I am the son in respect of the first wife. My learned friend's client is the second wife, spouse. Now, my lord, your lordship, after hearing, was pleased to file an affidavit. In affidavit, my lord, the state authority says that when two wives are available, who will be the eligible? That in that respect, rule is silent. The state says, my lord. Then, my lord, minus people put submission, the personal law will apply. In that respect, my learned senior, Mr. Pathasarthi Bhattacharya will argue, my lord, and there is several judgment. But in the meantime, what happened? They my lord,
want to have some personal difficulty. Day after
kindly fix time, my lord, priority, give some priority, my lord. 2 p.m. top, my lord, kindly if you already, my lord, is he appearing under the let's get day after tomorrow, 2 p.m., my lord, kindly third matter, my lord, third matter. (32) Abdul Malik. Second matter, my lord. Second matter. I'm deeply obliged, my lord.
Tomorrow there's some personal difficulty in the second half, and day after tomorrow, my lord, can you fix it up tomorrow the top, my lord, so that
not take more than 2 minutes.
my lord, 2.5 minutes maximum, because it's already covered by my lord's order. 831 and 249, my lord.
881 and 240. What are dimension top of the list? Top of the list, 1030.
1030 হলে ঠিক হয়ে যাবে
After 1030, it will take, the matters will take about 5 minutes.
নাকি এখন বলে দেবো ও
Or 1030.
হ্যাঁ টপে বলতে মেনশন মানে টপে হয়ে যাবে ফার্স্ট আইটেম মেনশন ম্যাটার
Can be 1030, my lord. Yeah, that's it. 249.
249, my lord. Deeply.
Good.